Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Prosaid, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Good afternoon. It is noon on Friday, August 1st, 2025. And welcome back to Massachusetts. Boy, we have a lot more to talk about today than I thought we would. And wow, just wow. As I went to pull up the thing that I was going to show you, it kind of disappeared. So give me a second while I pull it back up. And wow, just wow. I have reason to believe that really was Lindsey Gaetani in the chat the other night for the day. Well, I don't even, the days are all kind of blending together, but I have reason to believe that that was actually the real Lindsey Gaetani in the chat the other day, because if any of you were on the Young Jurks channel this morning trying to watch the live stream of Lindsey Gaetani's hearing today in Attleboro, I think she notified the court that Mike was trying to live stream it, and the judge threatened anyone who was trying to live stream that hearing from the Zoom with sanctions and possible incarceration. So welcome to the state of Massachusetts. God save us from the Commonwealth, because they don't want you to know nothing about nothing. They don't. And I don't know what this means for Zoom hearings being streamed in the future. Nope. Couldn't stream it. They kicked him out. They kicked him out of the hearing. Yeah, it's messed up. Oh, it's Kate Peter who called it in. Oh, she admitted it. Oh, isn't that so interesting how, certain people have control over what the courts do and what people are allowed to do in the courts. And yeah, so I guess you can listen to it yourself, but you can't live stream it. You can't record it. You can't tell anybody else about it. It's according to an SJC rule, apparently. I'm afraid to even play Young Jurks stream, but what I'll do is I'll listen to it in my ear and I'll repeat to you exactly what the judge said. And then we also have hot off the press, Cosgrove's response to Unimpound Town. And let me tell you what, Cosgrove does not want any of those messages unimpounded. He says they're under a protective order, and he says there's an investigation still ongoing. What does that mean in the Aidan Kearney case? We're going to take a look at those papers. We're going to take a look at Proctor's attorney filed a motion. So because Proctor really is afraid of the grilling that he's going to receive next Tuesday on the Rosemary Scapicchio barbecue. And he had his attorney file a motion trying to limit his testimony and what he's going to be allowed to testify to. We're going to look at that. And who knows if we'll even be able to watch that hearing next week after what happened today. So we got all the papers. I'll show you all the papers. I got all the papers. But Guess the judges in Massachusetts don't want anybody to see what they're doing, and they certainly don't want people live streaming it without prior permission. And from what I read on the interwebs, apparently Brian of LTL, it took him 2 years to get his media pass, to be able to even go into court as a court watcher with a media pass. So that's interesting. So how do you get permission? Do you have to make a motion on every single Zoom hearing that you want to live stream? Do you have to, can you get blanket permission if you're media? What if you're an attorney? What if you're a YouTuber? I don't know. I don't know. So it isn't shady at all, says Dee. It isn't shady at all. No, we see it, Court TV and like the bigger channels make motions to be able to have a camera in the courtroom for every big trial that they want to stream. But, it's the little things. It's the little trials, the little things that are going on with the side pieces and the side players in the big trials that they maybe don't want you to know about. Is it shady? Rhetorical. All great questions that need answers. Thank you. Thank you very much. Thank you very much, Gen X 1968, for saying the quiet part out loud. If you're just a nosy citizen, I think you're allowed to go to court and you're allowed to listen to the Zoom yourself, but you're not allowed to live stream it or record it. So that means that I can't play it live for you, apparently, without prior permission from the court. I don't know how hard that is to get. I don't need to know if I need to hire an attorney in Massachusetts to go in every single time and get me permission every time I want to Zoom stream a hearing. But this was in Attleboro. No, nobody got to live stream it, but I heard what happened, what the end result was. And apparently the end result, Lindsey Gaetani had a hearing this morning because apparently, allegedly, she told some woman, she threatened some woman, right, to kill her and her children. Didn't she threaten a woman to kill her and her children? A woman named Michelle, I think. If anybody knows the exact charges, let me know, because I really did not follow that one closely, to be honest with you. But now that she likes to come in my chat and chat me up, maybe we'll have to follow what's going on with her. But we just can't stream it live. Apparently, Lindsey Gaetani took a plea agreement this morning. 6 months probation with the requirement to complete anger management classes. She also agreed to a stay away order from the victim and her family. If it's broken, she faces 6 months in the House of Corrections. 6 months in the House of Corrections. Happy birthday to Jerry Garcia. Today's Jerry Garcia's birthday. He would have been 83 years old, I believe. 83, I think. I don't know. I don't remember what year he was born, actually. I don't recall. Anyway, so there's that. Because, I guess we have to make a birthday cake for Jerry Garcia. So you can go to court. They're going to have a lot more people showing up now. And so they're going to need a bigger boat, bigger courtrooms. I don't know. And it just cannot be live streamed. So that means that people like me cannot share these hearings with people like you and break them down for you in real time. That means that every single person who wants to get on the Zoom is going to have to call in. Maybe somebody said they wouldn't let anybody on the Zoom. Cocoa Paws said they wouldn't let anybody. Is it Adam Duritz's birthday too? Oh, he is one of the other poets of my life. I didn't realize he and Jerry Garcia shared a birthday. Really, Rachel? That's crazy. I love them both. Jerry and Adam, two of the greatest poets of my lifetime. As is Dave Matthews, as you know. Top 3. Those are my top 3. Soundtrack of my life. Attleboro is practically in Rhode Island. So that's apparently what happened to Lindsey. 6 months of probation with the requirement to complete anger management, and agreed to a stay away order from the victim and her family. And if she breaks that, 6 months in the pokey. But here's the thing. I'm sorry, what? My lighting looks off. Past couple videos, you look pale and green. Are all your lights on and proper settings? Things happen, like when they reset themselves and then the camera, the white balance might be off maybe. But don't worry, I'm not sick or anything. It could be the white balance on here. And, to be honest with you, let me see if I can, oops, see? And then it goes like, does the whole thing. Maybe you got to switch the white balance so it's not on auto. It needs a better temperature. I don't know. Does that less green? I don't know. I'm not a technology wizard. Are you, Colby? And the lighting is on a warm setting. I don't know. Everybody's always got stuff to say, but I do appreciate that because they don't want to look green. And then I put the light on white, you see, and then people say, "Are you wearing blue contacts?" I'm like, "No, I'm not wearing blue contacts. It just depends on what setting the lighting is on." I look pale and green. Not a compliment. Whatever. We'll try this. We'll try it this way if that'll make you happy. I'm not a cupcake. But I also don't want people to think I'm green. Oh, fucking no. Yeah, my teeth are glowing. Somebody said my teeth are blue. I have no idea. It's the lighting. I have no idea. My teeth are not blue in real life, but whatever. For the love of the God. Yeah, I haven't blocked Lindsey. So if she comes in, I may have to, but whatever. We'll see. See if she can behave herself. She likes to watch me. That's fine with me. I don't care. I don't care. They don't want anybody knowing the dirty deeds of the star players in the case against Turtle Boy. Thank you. I don't recall. I think you might be right about that. Oh, well, I think since we have this hot off the press, the Aidan Kearney opposition from Cosgrove, let's take a look at that first and figure out maybe what they mean by there's still an investigation ongoing. No idea what that means. No idea if we're going to be able to find out. No idea who that investigation is against or has to do with, but let's take a look at the papers. Shall we? All right. I can StreamYard is already acting up. So if I go out, I'll be right back. Don't ever worry, because I would never abandon you. Yeah, and the Boston Globe picked up the story about Aidan Kearney meeting Ben Affleck on the Cape. And they made a whole thing. They made a whole thing about it. Like, oh, is Ben Affleck going to be directing the movie? I mean, it's just like, did the Boston Globe have nothing else to report on? It's wild. I can't enlarge this because it's in a format that is not allowing me to enlarge it. So for whatever reason, it is single spaced. I've never seen anything like this. Try and keep the complaints to a minimum because there's nothing I can do. I can barely read it. If I full screen it, it goes off the screen. So here we go. This is the Commonwealth's opposition to Aidan Kearney's motion to release case documents from impoundment. The defendant, Aidan Kearney, has requested that several relevant and material documents held impounded from the defendant and or from the public view in the instant matter be released. Defendant's motion, page 1, emphasis added. Of course, that is not at all what the defendant moves for, as he makes clear in the very next sentence, wherein he moves that the Commonwealth be required to satisfy its heavy burden of secrecy as to each and every document it seeks to hide from public view. Defendant's memorandum, page 1, emphasis supplied. As the defendant correctly states, much of the discovery supplied over the last 6 or 7 months has been turned over pursuant to an agreement between the parties, admittedly entered into without prejudice. Okay, so without prejudice means you have the right to come back and argue again. With prejudice means you don't. That's my cursor on your screen, not a fly. Please do not break your TV and send me a bill. Thank you. The defense now indicates it wishes to withdraw its agreement. It seems to be a little confused, however, as to just what it has agreed to, which is not impoundment, as its motion states, but a protective order. As stated on the face of each such agreement endorsed as an order, the, quote, issuance of a protective order is the inherent authority of the issuing court, and protective orders serve to shield litigants and third parties from unwarranted disclosures, and as a practical matter, to facilitate the discovery necessary for trial. Commonwealth versus Fremont. The case law cited by the defendant largely deals with impounded documents filed with the court and is in opposite. The documents in question are not judicial documents filed with the court, but discovery provided to the defense. Under Massachusetts Rule of Criminal Procedure 14, the Commonwealth is required to provide the defendant with discovery that is relevant, a term of wide scope, whether that discovery is credible, material, or admissible in court. This includes material which may well be excluded at trial as prejudicial. It is not surprising that the defendant prefers to characterize the orders in question as impoundment orders, where First Amendment concerns, though not unlimited in scope, are at their zenith, for only in the most extreme situations, if at all, may a state court constitutionally forbid a newspaper or anyone else to report or comment on happenings which have been held in open court, and a similar rule would apply to court files otherwise unrestricted, citing Boston Herald v. Sharp. Consideration and emphasis differs for discovery documents subject to a protective order. As to discovery materials, a litigant has no First Amendment right of access to information made available only for purposes of trying his suit. The right to speak and publish does not carry with it the unrestrained right to gather information. As Justice Powell, writing for the unanimous court, explained, liberal discovery is provided for the sole purpose of assisting in the preparation and trial or the settlement of litigated disputes. Therefore, there is an opportunity, for litigants to obtain incidentally or purposefully information that not only is irrelevant, but if publicly released, could be damaging to reputation and privacy. The government clearly has a substantial interest in preventing this sort of abuse of its process. A protective order as to discovery materials entered on good cause that does not restrict the dissemination of information if gained from other sources does not offend the First Amendment. In general, the standard for protective orders is set forth in Massachusetts Rule of Civil Procedure 26C, which is analogous to the federal rule, provides in pertinent part that, quote, upon motion by a party or by a person from whom discovery is sought and for good cause shown, the court may make any order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. See the embarrassment section? Remember how Tim Bradel argued at the last hearing? Embarrassment of a public official is not a reason to keep these things from the public. He was talking about Michael Marcy's emails and text messages, perhaps. The scope of discovery and protective orders are issues within the sound discretion of the motion or trial judge. Secrecy is fine at the discovery stage before the material enters the judicial record. Protective orders are often blanket in nature, citing Shane Group versus Blue Cross Blue Shield of Michigan. The trial court has broad discretion to decide when a protective order is appropriate and what degree of protection is required. And great deference is shown to the lower court judge in framing and administering such orders, citing Public Citizen versus Liggett Group, Anderson v. Cryovac. Here's the next heading. Ample good cause exists to maintain the existing protective orders. The defendant has a well self-documented history of attempting to taint the jury pool to obtain the results he desires. Well, his last trial was a bench trial, so there was no jury pool to taint. But go on with your bad self, Cosgrove. And he's citing all civil cases. This is true. This is true. In the Karen Reed case, the defendant was candid as to the goal of his intent. I'm sorry. The font is really small. You have to cut me a little slack. In the Karen Reed case, the defendant was candid as to the goal of his internet presentations and other activities, his YouTube presentations. As previously noted, quote, in 8:30:23 jury influence, Kearney is shown speaking to his audience with a bullhorn. Quote, we need to continue to spread the word. Every single person in Norfolk County needs to know the truth about Karen Reed and John O'Keefe. We are trying to affect the jury pool. Yeah, that's exactly what I'm doing. End quote. I love watching internet presentations too. I have a sick looking hue. Oh, thank you so much for your compliment. What's wrong with people? I have a sick looking hue. Okay. Maybe I should just shut off my camera. Should I do that? Was Grace here? Grace, you mean maybe you have to come in and fix the camera settings because everyone thinks I look sick. I'm very well, actually. I'm very well. Oh, thanks, Grace. I got my roots done. Can you tell? A little color. A little color. Jealousy. That's a great song, Jealousy. Natalie Merchant. Was that Natalie Merchant or was that the 10,000 Maniacs? I don't know. Commonwealth's opposition to defendants McCarthy Odell motion to dismiss on the docket of a different case number. Or is it this case number? I'm not sure. In pursuit of that goal, for Kearney, extremism in support of Karen Reed was no vice. And moderation in pursuit of attacking witnesses, police, prosecutors, the judge, the jurors, the grand jurors, and even the late victim's family, the O'Keefes, who refused to bow down to Kearney's preferred narrative, was no virtue. I'm going to read that again because I don't understand it. In pursuit of that goal, for Kearney, extremism in support of Karen Reed was no vice, and moderation in pursuit of attacking witnesses, police, prosecutors, the judge, the jurors, the grand jurors, and even the late victim's family, the O'Keefes, who refused to bow down to Kearney's preferred narrative, was no virtue. Okay. If Kearney has a pet word to describe what he attempts to do to anyone who stands in the way of his objectives, it is destroy, in quotes. Again, as the Commonwealth previously noted, quote, in the aptly titled episode 616, Trying to Destroy Colin's Life, Kearney begins by musing about whether Colin's aunt, Jill Daniels, whose photograph he displays, has a crush on him, a proposition he modestly thought at first to be ridiculous. After asking his viewers to weigh in on this important topic, he opines that it's wild because I'm like trying to put her like godson / nephew in jail and like kind of like destroy their life, but she also likes me. Like what? End quote. 2 comments, : Daniels is not a witness in the Reed case, but as a relative of a witness, Kearney considers her fair game for humiliation. Second, Kearney explicitly states the goal of his behavior with respect to Colin, destroy his life. Well, if there's one thing Cosgrove just did, it has everybody running to Turtle Boy's website to look for episode 616. I'm not sure if that was a video or an article. So thanks for boosting his numbers, Cosgrove. Commonwealth opposition to dismiss at 26-27. His destroy the opposition approach was on full display when Kearney learned that someone had filed a bar complaint against one of Karen Read's lawyers, Alan Jackson. To a journalist, and he puts journalist in quotes, as Kearney sometimes styles himself, this might be news to report. Oh, that sounds like fighting words to me, Cosgrove. He's more of a journalist than any of the other local journalists in Massachusetts who covered Karen Read's case more extensively than any of them, and actually did a better investigation into the murder of John O'Keefe than the Massachusetts State Police and the Canton PD and the District Attorney's Office for hiding all of the video and the Sally Port video and so many other things. Another type of journalist, such as an opinion columnist, might express a view as to whether the BBO complaint was a good thing or a bad thing. Quote, journalist Kearney, however, immediately stepped into his role as the enforcement arm of the Karen Read team. These are really fighting words. The enforcement arm of the Karen Read team. First of all, I wasn't aware that anybody filed a bar complaint against Alan Jackson. Were you? Was that one of Aidan Kearney's articles that I missed? Thanks, Olivia Nile, for pointing out the obvious. This is not how an impartial prosecutor seeking justice writes. No, he's got a personal beef against Aidan Kearney, as does the entire state of Massachusetts. And that's insane. And there's no reason that he's not a journalist. He's written more than the columnists for the Boston Globe. Likely. Huh. I'm just looking at the chat to see if anybody knows anything about any BBO complaint against Alan Jackson, because I don't. It's right here. I'm going to read it again. This paragraph right here. His destroy the opposition approach was on full display when Kearney learned that someone had filed a bar complaint against one of Karen Read's lawyers, Alan Jackson. First of all, bar complaints are not public. To a journalist, in quotes, as Kearney sometimes styles himself. No, he styles himself that way all the time, not just sometimes. You're the one who calls him a blogger. This might be news to report. No, it's not news to report because they're actually not open to the public. Nobody would ever know about a bar complaint unless it reached the status of going to a hearing. Another type of journalist, such as an opinion columnist, might express a view as to whether the BBO complaint was a good thing or a bad thing. Journalist Kearney, however, immediately stepped into his role as the enforcement arm of the Karen Read team. All right, we're going to read on. Why is Cosgrove giving his personal opinion of what kind of journalist he thinks Aidan Kearney is? How is that relevant in any way to anything going on here and things that are impounded and things that the Commonwealth does not want you and me and the rest of the worldwide public to know? Quote, if you know where complainant Deborah Cora lives or whatever, we need to find it out, and we need to destroy her, ruin her, make it impossible for her to ever work again. Again, I don't make the rule, and a lot of people are like, no, we shouldn't do that. No, 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 effer. You fight fire with fire. I don't pick the battlefield. If they pick this, if that's how they want to do this, don't throw mud if you don't want to get effing dirty. That's it. I'm sure he's taking that out of context, but I don't know because he doesn't say what episode that's from. Zero relevance. So if anybody wants to find anything out about this woman, and that doesn't include her, that includes family, like let the record know if you do something like this, we're not going to stop at going after you. We're going to find out where your effing husband works, where your effing kids work, whatever. We're going to make life effing difficult for you. If you want to do this, if you want to go real world, and I say Patricia saying, no, let me explain to the Patricias of the world. You're at the wrong station. This is not the station where we act, where we be the bigger person. No, no. This is the place where if you try to F with somebody's career like that, we F with your career, okay? We give you bad Google reviews. We effing give you a problem, or no, or don't do it at all, or don't do it at all. Like, that's what I would suggest. I think none of us should do it. Yeah, Kearney's a meanie is what this is given, says Ain't So Plain Jane. Agreed. But if they're going to fight fire that way and you want to be like, oh, we should just do, that's bad. Oh, you're on the wrong channel. This is not a channel where we just be the bigger person. That's not what we effing do here. We fight fire with fire. If you want to F with people's lives like that, we're going to F with yours. Period, 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 period. You want to enter the arena? Now you're in the effing arena. You want to be in the game? Now you're in the game. Anyway, that's how it works. Oh, here it is. Episode 685. Karen Reed case. McAlbert agitators protected by Dedham police. Pedo Sims for Proctor. And he puts a link to the YouTube video in there. So for any of you who want to watch the video, you can. So thanks for driving up the views, I guess, on behalf of Aidan Kearney. And I'm pretty sure that's probably taken out of context. I don't know because I haven't watched it because I literally just got the papers a couple of minutes before we went live. The destroy rant against Cora, and thanks also, Mr. Cosgrove, Attorney Cosgrove, for outing this woman so that more people can try and find out who she is all the more remarkable given that Kearney already knew that she was a California resident, that the complaint had been made to authorities in California, and that it had been dismissed. But of course, the point was not to intimidate Cora herself, but to give notice to potential dissenters from the Turtle Boy line that they too could be destroyed. I'm still confused about how this is relevant, but I think what Cosgrove is trying to do here is pretty obvious. He's trying to paint Turtle Boy, aka Aidan Kearney, as a mean person who deserves to be convicted. So who's trying to taint the jury pool now, Cosgrove? Who's trying to taint the jury pool now? This is a publicly filed document, and sounds like that's what you're trying to do here. Kearney has continued his modus operandi in the Karen Reed case in, quote, reporting on his own case. Reporting is in quotes. Once again, he publicizes his upcoming court appearances and encourages his live viewers to attend court proceedings. Well, guess what? They're open to the public, whether you like it or not. And after what that judge in Attleboro did this morning, the crowds are only going to get bigger because you're trying to keep it from the public. Once again, the exterior of the courthouse is lined with picketers bearing sides. Once again, many of them are in shirts, some commercially sold by Kearney, bearing slogans designed to elicit public support. For example, journalism is not a crime. That's what the t-shirts say. Wow. God forbid the man make a living. And guess what else? Journalism is not a crime, Cosgrove, although you'd like to make it a crime. And who knows? Maybe they're trying to make it a crime in Massachusetts. Yeah, that's the fanciest thing I've heard him say, modus operandi. How dare he sell t-shirts and encourage people to come to court? How dare he? We don't want the public to know what's going on in court. And after he says journalism is not a crime, he says, true, of course, but witness intimidation is. Oh, is wearing a t-shirt that says journalism is not a crime witness intimidation? Or is he claiming that everything that Kearney is accused of is actual witness intimidation? Because, you know, they're just allegations till it's over. As Karen Reed supporters adopted pink as their signature color, so now Kearney is polling his viewers as to an appropriate Turtle Boy color. Oh, I'm sorry. Is that a crime also? I heard it's between purple and green. He likes purple. Some people like green. Purple's fine with me. I'll do purple. I have a purple background here right now, which has nothing to do with him. I just like purple. And I noticed everyone else is using purple lately too. So I guess it's popular. Wow. Kearney continues to harass witnesses and show up at their residences. Over the July 4th weekend, he and his, quote, current girlfriend, and that's in quotes too, current girlfriend, drove to the home of witness Brian Higgins, who noticed him in the car and moved to intercept him, leading Kearney to flee. Okay. Is Brian Higgins a witness to anything involving Aidan Kearney? Because last time I checked, Karen Read was acquitted before July 4th, so he's not a witness in that case. So where is Brian Higgins a witness exactly? There are no charges trumped up on Aidan Kearney with regard to Brian Higgins, am I right? But let's mislead the public, Cosgrove. We saw your mean streak when we watched the trial, the alleged violation of the HPO against Lindsey Gaetani. Because, Paul O'Keefe and friends brought her to court so that Aidan wouldn't have to leave at one of the Karen Read hearings. But Brian Higgins is not a witness with regard to anything that Aidan Kearney is charged with. You can correct me if I'm wrong, and I know you will. Over the July 4th weekend, he and his current girlfriend, in quotes, drove to the home of witness Brian Higgins, who noticed him in the car and moved to intercept him, leading Kearney to flee. Oh, really? What did Higgins chase after him and start cursing at him? Kearney has posted his own video account of the event online, casting Higgins as a fool and proclaiming his own innocent intentions. Well, seems like freedom of speech to me. Hang on. And then he links the YouTube video for that, which will also give Aidan Kearney more views. As with the Karen Read case, documents filed in court are immediately publicized and spun by Kearney. I guess that's what we're doing here. We're spinning. We're spinning. He's not accusing me. He's accusing Aidan, but Aidan's on vacation, so I'll take care of it. I got vacation duty, I guess. I'll handle it. Move to intercept him. I'm sure it was probably more than that. Aidan was driving. I think he was in the passenger seat, right? I think I did hear about this. Court appearances are often hyped by promises of bombshell revelations, end quote. That was also in quotes, bombshell revelations. Consider recent defense filings in the case and see, for example, Turtle Boy Daily News, Canton Cover-Up, Part 508. Isn't that also the area code up there, 508? That's interesting. Sworn affidavit alleges Commonwealth agent Kate Peter was paid $1,500 monthly, bribed with couch by Jennifer McCabe to spread disinformation about Karen Read while working directly with Hank Brennan and Michael Marcy at tbdailynews.com. I mean, it's having the opposite effect because now it's driving everyone to his website. So good on you. Kearney has a well-documented history of abusing discovery materials to harass witnesses. Again, as previously noted, when the Commonwealth provided defense counsel inadvertently and overgenerously with a complete download of one witness's cell phone, it was Lindsey Gaetani's cell phone, counsel immediately provided a copy to Kearney, who, in the face of an agreed upon subsequent court order that he would use only material relevant to his case, immediately proceeded to violate it. Well, let's point out a couple of things here. When the Commonwealth provided defense counsel inadvertently, apparently they handed over a full extraction of Lindsey Gaetani's cell phone, and overgenerously. Wasn't that so generous of you? Because usually you don't give any discovery. Usually you hide discovery, but it was overly generous of you. to release Lindsey Gaetani's entire and total phone extract. Whose fault is that, I ask you? Whose fault is that? Whose fault is that? Like handing over 4,000 blank pages when you told the judge at the last hearing that you were handing over, between 5,000 and 6,000 pages of discovery, and 4,000 were blank and another couple hundred were completely redacted. Whose fault was that? Maybe you should have been a little more careful about what you turned over. And then he has the nerve to say, counsel immediately provided a copy to Kearney. Well, he's the client. He's allowed to look at his file and the discovery materials therein. And then he says, who, in the face of an agreed upon subsequent court order. Oh, so there was no court order in place at the time, Cosgrove. Is that what you're saying? So he should just anticipate a forthcoming, possibly, court order not to disseminate the materials, and he actually did nothing wrong? Wow. Just wow. In the face, how could you be in the face of something that hasn't happened yet? How could something that hasn't happened yet be in your face? Am I being gaslit again? Am I being gaslit, Olivia? I know you're here. In the face of an agreed upon subsequent court order that was not in effect. Yeah, Fannie's going to backdate it like he did in the, was it the Brian Walshe hearings, where he agreed that he backdated some reports, that he wrote last week, that he backdated to 2023, because that's kind of what they do. Yeah, in the face of a court order that did not exist yet. In the face of an agreed upon subsequent court order that he would use only material relevant to his case, immediately proceeded to violate it. See generally paper 52, Commonwealth's motion for protective order and return of certain confidential information extracted from victim's cell phone. The subsequent Commonwealth motion to vacate this court's order of December 27th, 2024, in light of its manifest ineffectiveness, and to adopt the order of proposed herein, impounded, and exhibits presented in open court in support thereof, impounded, see court's endorsement of December 27th of 2024. Okay. So the court didn't order it till December 27th of 2024. And, he doesn't put the date in here of when these materials were allegedly published. But I think it was a long time before that they turned over the entire extraction. Okay. And the reason that I know that is because I was being trolled about releasing Lindsey Gaetani's records, because the Twidiots thought that I was behind the Haley Walbrecht account. This has to go back to, now that I think of it, like February, March of 2024. So I'm not sure if the records were the phone records, because I can't remember what I was being trolled about at the time. But I'm pretty sure that's when it was. The corruption never ends in Massachusetts. Never, ever, ever. Kearney, and then the next heading is called, but I just want to look at something. Let me see something here. Episode. I'm going to have to go back to that in a minute, because I can't find it right now because the font is too small. Okay. Next section. Kearney continues to utilize discovery to publicly attack witnesses in this case, delving into alleged character flaws and alleged misconduct that has no relevance to the charges before this Curt, C-U-R-T, capitalized. Which Curt do you think he's referring to? Curt Roberts, Carrie's husband? Isn't his name Curt? But is it Curt with a K? I don't know. and which, in addition to their emotional toll on the victims, can only serve to poison the jury pool. Despite Judge Krupp's order, Kearney has continued to use material he acquired through discovery to publicly harass witnesses. The Commonwealth directs the court's attention to the previously filed letter of March 26, 2025, by one such witness, filed pro se with leave of court, addressed to Judge Doolin, which liberally quotes from Mr. Kearney's online presentations, for which she provides specific citations and sketches in vivid detail the effects of such verbal assaults upon her. Well, what I find interesting here is that Cosgrove has chosen not to name this person. This is a court filing, yes. This is Cosgrove's opposition to Unimpound Town, let's call it. So I can only imagine that this witness who wrote this letter is probably a McCabe or an Albert, because clearly that is who Cosgrove has been hired to represent and defend here. Unrestricted use of discovery materials would facilitate Kearney's continued attacks on victims and witnesses. Everyone smash the like button while you're here. There's over 7,000 of you here, so let's hit the like button for a girl, eh? It has long been the case that relevant statements of witnesses are to be provided by the Commonwealth in discovery. Well, it has long been the case that that's what they're supposed to do. But as we've seen from the Karen Reid and other cases, oftentimes they turn over nothing. And as we're watching in the case of Myles King, Lally will return to the barbecue on Tuesday to continue trying to explain why he never asked Michael Proctor to give him any more than the 1.5 affidavit of the search warrants in the Myles King case, in the murder of Marquis Simmons. So yeah, they're supposed to turn over stuff, but we know what really goes on there. The widespread use of electronic communication has made it significantly easier for witnesses to communicate with prosecutors during the pendency of their cases. Massachusetts Rule of Criminal Procedure 14A2B1 requires automatic discovery of the written and recorded statements of a person who has testified before a grand jury, and written or recorded statements of persons the prosecutor may call as witnesses. Emails and texts fall under this definition. Oh, really? Because you haven't turned over any of them. And it's been how many years now? Of course, irrelevant statements need not be provided. Well, guess what, Cosgrove? It's not up to you to decide what's relevant. But relevance is quite broadly construed. It includes, for example, quote, any information reflecting bias or prejudice against the defendant. Massachusetts Rule of Criminal Procedure 14A2BC. In the present case, the defendant has created a cycle generating discoverable comments. He mocks, smears, or otherwise attacks witnesses and their family members online. His actions come to the attention of the witnesses, who then complain to the district attorney's office and ask if something can be done to ameliorate the situation. Right. Remember in Jennifer McCabe's hearing, when she tried to get a restraining order against Kearney, she said, well, can't something be done to make him stop blogging about me? Thanks, Cosgrove, for giving us a little peek into what's inside these materials that you're trying to hide and that you don't want uncovered. There's probably text messages going back and forth about how we got to put Kearney in jail, and about how Kearney's a threat and you need to incarcerate him. And this is he's telling us exactly what they don't want to turn over, or they don't want to be made public. Communications between the witnesses that Kearney is accused of intimidating, the McCabes, the Alberts, Julie Nagel. Carrie Roberts is not one of them. There's no charges for Carrie Roberts. He's telling us everything. Proctor Buchanan, although I think their charges may have been dismissed. Any sort of communications between those people and the district attorney. between those people and Proctor, between those people and Buchanan. And if Proctor said the horrific things that we know about Karen Reed, what kind of things do you think Proctor might have been saying against Aidan Kearney? What kind of bias do you think might be in those text messages between Buchanan and the witnesses, between Michael Marcy and the witnesses? I submit to you that it could be far more explosive and show far more bias than we saw in the Karen Reed case. What do you think? Those statements, while often saying nothing about the facts in the indictments before the court, arguably inform the Commonwealth of subsequent bad acts of Kearney and often express bias or prejudice against the defendant and therefore are discoverable. Well, he's telling us exactly what's happening here. But how can they inform the Commonwealth of subsequent bad acts of Kearney's? How do they know what Kearney is going to do next? They're telling on themselves right now, and he's telling on them in this filing, and he's telling us that what is in Impound Town right now is explosive. Thank you, Nurse Kim, for creating the Impound Town phraseology. Often express bias or prejudice against the defendant. Well, how is that not relevant? We know, because we've been paying attention, that they would stop at nothing to put Aidan Kearney in jail. They would stop at nothing. We know that because the Bettero letters told us that there was a text chain on the night in question between not so confidential informant, mafia asshole Kate Peter, Lindsey Gaetani, the alleged victim, Brian Tully, the lieutenant, whatever the hell he is, of the MSP, and Ken Mello, the predecessor to Robert Cosgrove as special prosecutor of Aidan Kearney. There was a four-way text group while Aidan Kearney was in the bathroom at Lindsey Gaetani's apartment. In my opinion, it was clearly a setup, and I think that these text messages and these communications that Cosgrove doesn't want unimpounded are going to show exactly that. Exactly that. So thanks for telling us everything. Let's keep reading. Bias, in quotes, he says, bias against Kearney is the least difficult thing the defense has to prove. Well, thank you for that. And why is bias in quotes? Because he deserves it? Because he's not your definition of what a journalist is? Because he's written more articles and he's done more investigative journalism into the murder of John O'Keefe than your people? He's self-snitching, James. He's self-snitching. Bruce Rivers, if you're out there, do a video on this. Cosgrove is self-snitching. Bias in quotes against Kearney is the least difficult thing the defense has to prove. Thank you for that. So you're admitting it? Should the court take judicial notice that every single investigator in this case has extreme bias against Aidan Kearney, as does the district attorney's office of Norfolk County? Are you going to admit that? That's interesting. Why would the witnesses not loathe Kearney given his treatment of them, and why would they not freely admit to doing so? I can't wait to see these messages. Ironically, the credibility of the witnesses and their potential bias does not loom large as a factor in most of the indictments before this court. Oh, really? I would submit to you that Jennifer McCabe's credibility is 100% in question. She lied to the FBI and admitted to doing so on the stand during the Karen Read trial. Are you kidding me? It absolutely does loom large. And you guys have been squawking all along about Proctor not being biased in any other investigations, only the Karen Read investigation. And you're going to see when we read the motion of Proctor's attorney after this, how scared he is about being questioned about other things outside the scope. The Commonwealth's evidence is largely based on Kearney's own statements and actions, lovingly recorded and broadcast by him. Lovingly recorded. Now we're in a romance novel for all the world to see. These videos speak for themselves. There can be no serious dispute as to his actions. Whether they are, as he claims, mere First Amendment free speech, or whether whatever their speech component, they cross over the line to intimidation, is the issue to be tried by the jury or the bench, depending. As the witnesses' communications with the district attorney's office, many doubtless written in the mistaken belief that they would not be turned over to the defense. Well, whose fault is that? The mistaken belief. It is a mistaken belief. Too bad, so sad. Maybe you should have advised them better. Maybe Tully should have advised them better. Maybe that's why in the group text messages between Brian Albert, Nicole Albert, Matt McCabe, and Jen McCabe, they said, don't want to text about it. Let's not text about it. We'll learn more tomorrow. Amber, I have never seen the word lovingly in a court document before, ever. This is a first. As the witnesses' communications with the district attorney's office, many doubtless written in the mistaken belief that they would not be turned over to the defense, come to Kearney's attention, they provide him with roadmap as to which of his attacks have caused the most pain, and they are grist for further attacks. For this reason, if no other, the protective order should stand. So the protective order should stand to further stifle the First Amendment. Okay, I guess I see what he's trying to say. Next section. Much of the material covered by the protective orders is under protective order in the recently concluded case of the Commonwealth versus Karen Read. Various emails and other communications between witnesses in the Read case and family members and the district attorney's office were turned over subject to protective order in that case. These documents are readily identifiable by Bates stamps. Yeah, because Brennan decided that he was going to be the one to Bates stamp everything. Because these witnesses were, for the most part, alleged victims in the present case. Well, at least you're admitting that they're alleged victims in this case. At least you're admitting that. The same documents were provided here. Indeed, the language of the protective orders intentionally largely tracks those entered in the Read case. Defense counsel asserted in open court that those orders became inoperative essentially automatically upon the conclusion of the Read trial. The defense cites no case law for this proposition. The Commonwealth's view is to the contrary, and the orders in place here, insofar as they track those in Read, are necessary to protect the existing Read orders. Well, it's kind of on hold right now, isn't it? Release of certain discovery material could jeopardize pending investigations. Oh, here's where he's really telling us everything. Routinely cited in the Read protective orders is a representation by the prosecutors that, quote, certain materials being provided as discovery in this case may be evidence in unrelated pending criminal cases. This language has been duplicated in the Kearney protective orders. Undersigned counsel as a special prosecutor, unlike all but one of the prosecutors assigned the Read case, cannot claim familiarity with other cases being prosecuted by the Norfolk District Attorney's Office. However, he can attest that some of the discovery turned over bears on an ongoing investigation in which he is involved. Counsel is prepared, if necessary, to make an ex parte showing to this court to verify the existence of that investigation. Well, what does that mean? What are they investigating? Something is still being investigated? Are they trying to put more charges on Aidan? Are they trying to put more charges on Karen Reed? Are they trying to put more charges on other people? Or charges on other people that could be related to these text messages? What's the pending investigation? Are they really going to keep doubling down on this? Are they really going to keep going after Aidan Kearney, Karen Reed, or other people that have to do with either one of these cases? I don't think it's a federal investigation because he says, however, let me read this a little bit more closely. Release of certain discovery material could jeopardize pending investigation, and then the S is in a parenthesis, investigation or investigations. Routinely cited in the Reed protective orders is a representation by the prosecutors that certain materials being provided as discovery in this case may be evidence in unrelated pending criminal cases. Okay, so that means unrelated pending criminal cases to the Reed case would be Aidan Kearney's case, Brian Walshe's case, Myles King's case, and a couple of other defendants that we saw that are trying to get Proctor's messages to prevent them from being destroyed, which was supposed to happen 30 days after the conclusion of the Karen Reed trial, which would have been July 18th, but none of the other defense attorneys were told until the day before, for example. Then he says, this language has been duplicated in the Kearney protective orders. Undersigned counsel, meaning Cosgrove, as a special prosecutor, unlike all but one of the prosecutors assigned the Reed case, okay? I think he's talking about Laura McLaughlin. Okay, just trigger warning to anybody with misophonia. Laura McLaughlin, because remember, Laura McLaughlin was called out in open court by the judge because she's also prosecuting the Brian Walshe case. And the judge was like, wait a second, you've got access to everything. Why didn't you look through it to see if any of it was relevant to Brian Walshe? So I'm assuming here, process of elimination, he's referring to Laura McLaughlin. Cannot claim familiarity with other cases being prosecuted by the Norfolk District Attorney's Office. She did. McLaughlin did say there was stuff in the Proctor text that affected Walshe. Yes, she did. That could be exculpatory, in fact, I think she said. However, he can attest, he meaning Cosgrove, undersigned counsel, he doesn't say I can attest. Is he talking about himself in the third person? He came out of retirement for this BS. Can you believe it? He can attest that some of the discovery turned over bears on an ongoing investigation in which he is involved. Is he saying he meaning himself, Cosgrove? Because Laura McLaughlin is a she. So are you, Cosgrove, involved in an ongoing investigation? And if you are, since you're a specially hired district attorney for the sole purpose of persecuting Aidan Kearney, can we assume from your papers that you're talking about Aidan Kearney? Because you would not be involved in any other investigation. Am I right? As far as I know, he came out of retirement as a retired Norfolk County judge to persecute Aidan Kearney. And so he would not be involved in any other ongoing. This is my process of elimination. I'm brainstorming with you because this is a cold read for me. Counsel is prepared, if necessary, to make an ex parte showing to this court to verify the existence of that investigation. Okay, so that is him. Cosgrove is the counsel. He's prepared, so he knows whatever this ongoing investigation is about. And the only thing that he would know about an ongoing investigation of is Aidan Kearney. Gabby 22 says, are they still trying to indict Karen and Aidan for conspiracy regarding witness intimidation? And would that be why they don't want to turn over Karen's phones? Aries Girl says they're still trying to pin down Turtle Boy and Karen Reed is what I'm thinking. Hence the whole BS with Hank wanting Turtle Boy's records. Gabby 22 said, are they still trying to indict Karen and Aidan for conspiracy regarding witness intimidation? I don't know. Process of elimination. We're brainstorming. He's talking about Marcy? I don't think so. It sounds like he's talking about himself, but who the hell knows? Triple dip Cosgrove. Conclusion. This is not an impoundment case. For the reasons set forth above, the court should exercise its broad discretion to find that the particular circumstances of this case amply justify the protective orders it has issued. This court is free to modify its discovery orders at any time. That's right, they are. But any change should be narrowly drawn and made on a defense showing of particular need. XOXO. Robert Cosgrove. And here's an appendix. And the appendix is a post on, I don't know, Facebook? Maybe? Is this a Facebook post? I have no idea. By not Haley Wolbrecht. Undated. It says, look what popped up on mass courts. There is a whole list of things I never want to see. This filing is like a whole new dimension. We used to only have to worry about third parties. Now we also have to look out for fourth parties. Oh, also parties, plural. I'd say it's time to make a deal. She can keep all of that stuff and we'll just take the incriminating information from her phone that we all believe shows that her and her friends entered into a criminal enterprise with some assistance from government officials in order to frame Aidan Kearney. Also, pro tip, when the entire internet is literally focused on you constantly calling yourself a victim, maybe don't publicly file a court document where you refer to yourself as a victim 30 times. So I don't know why this is an appendix and not an exhibit, because I don't know where he referred to this in the papers, but they're so hard to read because they're single spaced in like 8-point font. And that was just dated yesterday, July 30th, by Cosgrove. Oh, thank you, Olivia Nile. If you zoom in on the appendix, you can see their Gmail account and who sent them that screenshot. Oh, it's from Lindsey to Turtle Boy. There's an email back there. So yeah, looks like Lindsey's the one who sent it. And it looks like she sent it to Tully, Brian, from Lindsey. You can see it right there. Oh, well. Sorry, Lindsey, but this is a public court filing, and Cosgrove didn't know how to Redact your info. Can you guys see that? Thank you, Olivia. Although we can't see the date on it. Maybe you internet sleuths can be better than I am. Let's say better than I, and can read it because I can't read it. Lots of other things she sent apparently as attachments in this email. As you can see, 5 attachments from Lindsey to Tully. Because she's got speed dial. She got Tully on speed dial. Just when you thought you could like make it up, you just can't. You just can't make it up. This is gold, Jerry, gold. Gold. But I want to know what this ongoing investigation is all about and why Cosgrove is involved in it, because he wouldn't be involved in it if it involved anyone other than Aidan Kearney, because he's only hired for the Aidan Kearney case. Unless you know of any other cases that he's been hired on, you tell me. Tully isn't in the DA's office anymore. I think he was rehomed. Let's get to the chat. Cheryl, thanks for becoming a new member. Chidi's got the silver bracelets ready as here, and she gifted 5 memberships. Thank you so very much. Happy birthday, Jerry Garcia. Thanks, Raven, for your super chat. New member. Joy became a new member. Welcome. Kyle says, today is my wife's birthday too. Official old lady. Happy birthday to your wife, Kyle. Thanks for your super chat. Mindy says, now could you please wish my son, David Matthew, a happy 35th birthday. Happy birthday. Happy birthday, Matthew. I'm sorry, David Matthew. Happy birthday, David Matthew. You're 35 today. Enjoy it. Enjoy it while you're young. From your mom. Thanks for your super chat. Jennifer says, the court has to acknowledge your journalism credentials in order to get permission, which excludes a lot of YouTubers. It's gatekeeping. Well, there's a 2 p.m. hearing that's supposed to happen on Brian Walshe today. So I guess we're not going to be able to watch that unless one of the majors is live streaming it, like one of the networks. So if you know if one of the networks is going to be live streaming the Brian Walshe hearing at 2 p.m., please email it to me. Thank you. Kate Marie, just have to throw out there, there's my birthday too. Happy birthday. Happy birthday, Kate Marie. Thanks for your super chat. Thank you very much. Brigitte says I look fantastic, not green. Thank you so much for your super chat. Gigi has the silver bracelets ready again and says these clowns went to law school underwater without any available oxygen. Still do not think that they have come up for air yet. It's looking that way. It's looking that way. For the love of the traveling trooper, time for Bettero to lower the boom. This is crazy. I mean, just when you thought it couldn't get any crazier, it gets crazier. Right? Thank you for your super chat. Mark, thank you for your awesome videos, Melanie. Thank you so much for hanging around with me for 10 months, Mark McKay. Gigi gifted another 5 memberships, 10 new members today. Welcome. Enjoy the special emojis that we have because a lot of them are applicable. We are outraged is just one that I can think of right now. Thanks, Gigi. Gigi says, thanks for spinning the court documents into yet another wonderful internet presentation. You look beautiful and mods are working like machines. Thank you. I know the mods are the best. The mods are the best. Thank you for your super chat. KC Cat. Cosgrove needs a Snickers and a tissue for his salty tears. Yeah. Yeah. I kind of thought he was just kind of like, I don't know, But then when I saw him cross-examining Meredith on the stand during Aidan Kearney's bench trial, I saw a little flash of evil come out. Well, somebody better tell brother counsel that if he plans on streaming the Brian Walshe hearing, he could go to jail, according to the judge from the As Such. Oh, NBC 10. All right, good. We can watch it on NBC 10. Cool. Thank you. Thank you very much. I agree, Casey Cat. Christine, Melanie, your color is fine. You look lovely as always. Thank you for your super chat to tell me. A nice compliment. I appreciate that so much. Dying my way through life or DIYing my way through life. Became a member. Welcome. Karen Reed is free. Hulda, Iceland, Spain. Wow, I haven't been able to see a live show in ages. Well, good. I'm so glad you're here with us today. Tony, thank you so much for your compliment. My 19-year-old walked in today and said something. I'm not sure what, but thanks for hanging out with me for 5 months. For the love of the traveling trooper, paging Mr. Bettero, paging AJ. Time for SmackDown. Well, it'll be Bradel and Betterow that will smack it down because Cosgrove's really, really trying to keep this stuff out. And we can see how explosive it's going to be. How explosive it's going to be. And how bad it's going to make certain people look. And that's the reason Cosgrove wants to keep it secret. He says it's not impounded, it's under a protective order, but he also said, as we know, the judge can modify that protective order at any time upon good cause. And the good cause just might be to show the bias in the prosecutors and the law enforcement that were involved in setting up Aidan Kearney to get him in jail, to get him there. And he spent 60 days there. Tony says, can you please put Chaka up in the corner because we are again in the land of the lost? Yes, I will. Motion granted. Here's Chaka. For those of you who remember the land of the lost, he's from land of the lost. And we put him up there occasionally. He freaks me out a little bit, but because we're in the land of the lost. Can't wait to hear from Betterow. Betterow can't talk about this. Betterow can't talk about it because this is his case. So he can't. But when he writes a letter, we'll have it. We'll get it. It'll be part of the court file. My 19-year-old daughter loves you just as much as I do, by the way. Oh, thank you, Tony. Thank you so very much. Hare says, Cosgrove is self-snitching. Thank you, James Hare, for your super chat. K-Cat. Casey Cat, this is one of the weirdest motions I've ever seen. Unprofessionally written and so much self-snitching. Now we all need all of the text chains. All of them. GG. The motion, font, spacing. A 2-year-old could have done a much better job. Guess they want to continue to FAFO. Maybe. It's just, it's making this a bigger deal. Making it more interesting now to the public, him doing this, because now everybody wants to know. For the love of the traveling trooper, this letter proves the Commonwealth will never give up info. Well, if the judge says that it can be unimpounded, it can be unimpounded. Lawyer's daughter says, Lally? Yes, but Lally is not involved in the prosecution of Aidan Kearney. And Lally is not involved in the prosecution of Brian Walshe. So that's why I think they were talking about McLaughlin, but I could be wrong. Thanks, Lawyer's daughter, for super chat. I picture the judge whispering, what the hell is he talking about, says Casey Cat. Thanks for your super chat. Is it possible that Karen Reed's 1983 will shut this down? It hasn't been filed yet, as far as I know. Nothing's been filed. That it will shut down a further investigation? No, they can do whatever they want. I don't know who they're investigating or what they're investigating, but if Cosgrove knows about it, my inkling would be that it has to do with Aidan Kearney. Thanks, Kyle. GG, Feds, I am engraving the bracelets as we speak. Thanks. She's got the silver bracelets ready. Thank you, MMG in Richmond, for your very super sweet compliment and also for being with me for 14 months. Cosgrove needs ChatGPT, says Bruce West. Problem with ChatGPT is that it cites cases that don't exist, so the case law isn't real. And there are a couple of New York attorneys that got in big trouble in federal court because they used ChatGPT to look at, to write their federal briefs. Was insane. Tracy Fagan, eBay Warehouse says, what? Crazy. Yeah. It's all crazy. Yes. Got it. So there's that. However, there's one other thing that I just wanted to make note of, so give me a second. I'm sure a lot of this stuff is taken out of context. I'm sure a lot of it is misquoted, and I'm sure a lot of it is wrong, but I'm sure that when Aidan is back from vacation, he will address them on his show. And also, I'm sure that in whatever, well, are they going to, do they have an opportunity to reply to this? Aidan's attorneys, they can probably reply to it. I don't know Massachusetts rules, but in New York, you can reply to an opposition. Or they'll address it in open court. All the things that he misquoted or said that were inaccurate or. Thank you, Goodmans, for gifting a membership. You're amazing. And we know that Cosgrove likes to take information from certain people and just put it out there as truth, when oftentimes He's not right. It's not right. So that's interesting, isn't it? Here's what happened this morning when the Young Jurks tried to stream the Lindsey Gaetani hearing. I think it's still up on their channel, but let me just repeat to you as I listen to it in my ear what the judge said on the Zoom. I'm gonna. Oh, the video is now unavailable. Oh, well, it's a good thing that I screen recorded it. Hold, please. James Craig is guilty. Yes, that's kind of old news by now, isn't it? James Craig is guilty of everything, right? All of it. It was removed. I don't know. All right. I have to get my other earbud so that I can repeat to you what the judge said. But she said, anybody who's trying to live stream this hearing without prior permission, as required under the SJC rules, can be sanctioned or incarcerated or held in contempt of court. So if anybody is on the Zoom, I've been advised that somebody is trying to live stream this Zoom, you will be removed. And then Mike wasn't on the screen, so I don't know if he wasn't home or whatever when he was trying to live stream it. Could be. And then a minute later, she said, I'm aware that this person is still trying to live stream the hearing. And who do you think was telling the court that? And then they disconnected him from the call. And then the video has been taken down. And they really, really, really don't want you to know anything about what's going on. So there's that. Let's take a look at the motion filed by Proctor's attorneys, trying to get Proctor out of, not really out of testifying, but out of having to testify to more than a very narrow scope of things in next Tuesday's hearing. And this was a motion filed in the Myles King case, which you know, Rosemary Scapicchio, my new spirit animal, is the attorney for Myles King. There was a co-defendant, Brianna Gardner, but it was announced at the last hearing that they're not going to prosecute her. So I don't know if those charges were dropped in exchange for her testimony. I'm not quite sure, but they did file a null pros against Brianna Gardner. So that remains to be seen. And that hearing is supposed to happen on Tuesday. So let us look at the motion, because remember, Proctor was a no-show at the last hearing. I was on vacation when we covered it. Proctor was a no-show. His lawyer showed up. He did not. Lally was forced to get on the stand, and Lally embarrassed himself and the entire Norfolk County DA's office to the extent that Mark Betterow thought that he should be fired immediately. And Lally's been working at the DA's office for 20 years, since 2005. So how long do you think he's been doing this? Proctor was allegedly on a vacation. Yeah, allegedly. That had been, scheduled a long time ago. But let's take a look at the motion filed by Proctor's attorney in the Myles King case on July 30th, which would have been 2 days ago. Wednesday. Hang on one second. Okay. In the Commonwealth versus Myles King. Third party Michael Proctor's motion to limit scope of appearance for hearing scheduled on August 5th, 2025. Michael Proctor, a third party who is the subject of defendant's subpoena that has been issued in the above referenced matter for Mr. Proctor to appear at a hearing for July 21st, 2025, and now scheduled for August 5th, 2025, and who moves this court to limit the scope of examination and permit the undersigned limited permission to participate in the hearing. Number one, the court should limit questioning to the investigation into this matter. Pursuant to the relevant subpoena, Mr. Proctor is required to bring to the hearing any and all documents relating to the Commonwealth versus Myles King, including any and all communications between any law enforcement agency, yourself, and or the Norfolk County District Attorney's Office related to Commonwealth v. Myles King. Mr. Proctor has reviewed the subpoena and that the court's memorandum and order dated June 17th, 2025, and Mr. Proctor will be prepared to testify as to his communications with any law enforcement agency and or the Norfolk County District Attorney's Office related to the Commonwealth versus Myles King. Mr. Proctor requests that this court narrow the questions of the parties to topics related to matters identified in the subpoena and to the investigation of this case. Any such questioning about the Karen Read matter or matters outside of this case are not relevant to this subpoena of the recent alleged discovery issues in this case. He's scared because, if I recall correctly, Rosemary Scapicchio, when she had Lally on the barbecue last time, was asking him about his custom and practice and his habits. And, do you usually follow up? Why didn't you follow up with Proctor to get those search warrants? And so Proctor's attorney seems really, really nervous about Proctor having to testify about anything outside of the Myles King's case and what he's been doing during his time with the MSP assigned to the Norfolk County DA's office, because it is very relevant, right? Because it shows a pattern of behavior. He doesn't want to have to testify about anything outside of this scope. And I don't know whether this judge is going to grant this or not. But let's keep reading. Consistent with Massachusetts Rule of Criminal Procedure 14.2e, footnote 1, that rule requires when a party has provided all discovery required by Rule 14 or Rule 14.1 or by court order, it shall promptly file with the court a certificate of compliance. Consistent with Massachusetts Rule of Criminal Procedure 14.2, E 14.2e, Michael Proctor has conducted a good faith search of his personal property within his custody and control and has determined that he is not in the possession of any documents related to Commonwealth v. Myles King, including any communications between any law enforcement agency, the Norfolk County District Attorney's Office, and or himself related to Commonwealth v. Myles King. Well, it's just like, trust me, bro. Trust me, bro. I'm the attorney, and I'm saying that Michael Proctor has looked, and he doesn't have any emails or any text messages or anything in his possession having to do with the Myles King case. It also came out recently that didn't he destroy his phone sometime maybe in February of 2024? I don't know. Remember, this is a different case now. This is the Myles King case. But I think he did. There was some evidence, I think, that he did destroy his phone. But as you know, if he did destroy his phone in something like February 2024, text messages did surface after Karen Read's mistrial that he was still communicating, or during deliberations in that case, he was still communicating with the DA. So that would have been on his new phone. Or Lally. Maybe I'm conflating cases, but I thought that he destroyed his phone in February of 2024. Take that under advisement, because I may be conflating it with something else, but I thought I saw that somewhere or read it in an article. Mr. Proctor believes any relevant communications would be located within the Norfolk District Attorney's Office and or the Department of State Police for the Commonwealth of Massachusetts. Additionally, Mr. Proctor was relieved of duty from the Massachusetts State Police on July 1st of 2024, and since that date, he has not had access to any documents held by the Massachusetts State Police or the Norfolk District Attorney's Office. Well, we also know, Proctor's good faith is a joke, says Bubsy, and we also know that he used his personal phone to communicate with so many people. When he was texting his buddies about Karen Reed, and he was texting his superiors about looking for nudes. And so those things would not be necessarily in the possession of the Norfolk DA's office file and or the Department of State Police for the Commonwealth of Massachusetts file. He's been locked out of the office and his access has been denied. And I know that Brian Higgins and Brian Albert destroyed their phones, but I also heard that later Proctor destroyed his phone. Oh, thank you very much. Tiffany says, Melanie, you're right. The last filing from Michael Proctor's lawyer said he got rid of his phone in February of 2024. Thank you, Tiff. You are always on it. You're always on it. Therefore, the subpoena should be modified to relieve Mr. Proctor of any further duty to search for documents sought by the subpoena. Just trust us, bro. Number 2, Mr. Proctor's undersigned counsel should be afforded limited permission to participate. Oh, here's where it gets interesting. Mr. Proctor is currently a civilian witness, having last worked for the Department of State Police on July 1st of 2024, which coincidentally, by the way, I'll break from the document to remind you, that was the day that Karen Reed was acquitted. Wasn't it? No, July 1 of 2024 was the day of the mistrial. The acquittal was June 18th, 2025. He is not a party to the underlying case. No, but I think he was the lead investigator in the Myles King case. Mr. Proctor is now being called to testify as a result of the scope of his work, in this case arising from his duties as a detective. Despite his previous role as a detective involved in this case, it is unclear whether the prosecutor will act on his behalf in submitting objections to questions presented by defense counsel and whether he will probably whether he will properly rehabilitate him if necessary while on the stand. Wow. He's saying that he has a good faith basis to believe that the district attorney who is trying the Myles King case will throw Proctor under the bus and not protect him, and he needs protection. And so he should be allowed to object. Consequently, the undersigned counsel must be given the opportunity to question Mr. Proctor at an appropriate time so that the full record of his relevant conduct surfaces, especially if the parties are allowed to question Mr. Proctor on topics beyond this case. While Mr. Proctor has expressed regret for the conduct that has led to his termination, which is currently on appeal, there it is. His termination is on appeal. Does anybody think they're going to give him his job back? During the high profile and international publicity of the Karen Reed trial, he was the target of an extraordinary level of character assassination that has caused him to be the subject to a constant barrage of media scrutiny over the past 18 months. And as such, Mr. Proctor and his family has suffered persistent threats from anonymous persons. Therefore, with the anti-Proctor sentiment perpetrated by the media and public figures sympathetic to Karen Reed, Mr. Proctor must rely on questioning by counsel to bring about relevant information and dispel misinformation about any allegations of misconduct in this case. Well, Anti-Proctor sentiment. That should be the headline if anybody is going to actually report on this. Proctor's attorney alleges anti-Proctor sentiment perpetrated by the media and public figures sympathetic to Karen Read. What public figures are sympathetic to Karen Read? Has the media been pushing an anti-Proctor sentiment? Marico says, we can't claim that credit. Proctor proctored himself by himself. That may not occur without counsel for Mr. Proctor receiving permission to question him, the authorization to object, and standing to argue, period, standing to argue. Mr. Proctor continues to ask this court to narrow the parties' examinations of him to this case, which, if granted, counsel would expect to participate very little. But in the event the parties are permitted to get into areas of conduct stemming from the Karen Read matter, counsel respectfully requests the opportunity to rebut arguments by examining Mr. Proctor. So he wants, Proctor's attorney wants to be able to question Proctor, to clean up anything, to clarify anything, to make it look like he's not the bad guy here and didn't do anything wrong. But at the time of his work on the case of Myles King, he was employed by the MSP. I don't see any case law in this motion. Conclusion, wherefore, because of the formerly stated reasons, Mr. Proctor requests that the court accept this notification that he is not in the possession of any documents sought by the subpoena, narrow the scope of examination to this case, and allow undersigned counsel to ask relevant questions of Mr. Proctor if required. Yeah, Proctor's attorney is a magician. XOXO, Daniel Moynihan. Stone him. I'm assuming since he's a civilian witness, this is not a union like appointed attorney that's representing him. This must be a private attorney. Daniel Moynihan, don't know him. But we heard the judge the other day when we watched the hearing say things like, I don't know, where's your client? Like, I remember that he got up and asked something, and I think the judge just shut him down. I was like, yeah, no. And who was it? Was it Judge Doolin? I think it was Judge Doolin, right? So this was just filed on the 30th. And they really, really, really want to keep Proctor out of any more hot water. Because, you know, he does have the right to get up there and plead the fifth if there's anything that he could be like criminally prosecuted on. But apparently he's not intending to plead the fifth. He just only wants to testify about what his investigation into the Myles King case. And he doesn't want to have to be asked if he looked at any documents or has any documents or text messages. He just wants the judge to take the attorney's word for it that he made a good faith search and that he doesn't have anything. So this cannot be cross-examined. And also, this is not even in affidavit form by the attorney. It's just a third-party motion. And I don't think there was an affidavit filed with it, unless there was, and I just don't have it. Scooter 54 says, the attorney's magic wand is broken. I don't think the judge will put it. Oh, it's Judge Krupp. It was Judge Krupp that did that hearing? Yeah. He didn't seem to want to put up with it, right? K-Cat gifted 5 memberships. Thank you so much, KC Cat. KC Cat. I don't know why I keep wanting to say K-Cat. Welcome to 5 more new members. Ms. Holmes 66 says Proctor is going to be relieved of being questioned. No, they just want it narrowly tailored, and they want his attorney to be able to get up and defend him. And help rehabilitate him in the event that the district attorney considers him to be damaging to his case and doesn't protect him and properly object. Patio says Lally is involved in the Myles King case with Proctor, but no longer. Not anymore. It was taken away from him in the fall. It was taken away from him in the fall and it was transferred to another attorney. Thanks, Patty. But that's why he's on the stand. And so he's not involved in that case anymore. It was taken away from him. And he testified to that at the hearing, right? Thanks, Attorney Wannabe, for gifting a membership. You're awesome. Jojo, sir, what shade of audacity is this? I don't know. Like the reddest of red, like the scarlet letter. Thanks, Jojo, for your 10. Venus Blue, I'm happy that you are sticking with the Canton Crazy. Oh, I'm so far deep into it now that there's no way that I can't not cover it anymore. Does anybody know this attorney, Moynihan? Daniel Moynihan? I don't know. Guess we'll see. Yeah, Marianne Kruger says, I guess we're going to have to start calling Proctor Bubble Boy. Bubble Boy. I will allow Seinfeld references at any time. Do you remember the Bubble Boy episode? Thanks, Marianne Kruger. Okay. We can move on to the Brian Walshe hearing at 2 p.m. I think that NBC 10 is going to stream it live, but it kind of just says follow along here. For a live stream will be at the top of this story when the hearing begins, which is expected around 2 p.m. Okay. All right, so we can do that. We got like 17 minutes, and we can pivot over to that. Sound good? Thank you, Rhonda, for helping me. Help me, Rhonda. Rhonda helped. Stephen, no surprise, they're continuing to attack Arkansas. In my opinion, they are doing this in order to hide the corruption. Oh, I'm sorry. When I saw AK, Aidan Kearney. No surprise, they're continuing to attack Aidan Kearney. In my opinion, they are doing this in order to hide the corruption in Norfolk County. The corruption goes much higher. I agree. I've said that since the beginning, but I think there's a lot of play here. This goes far deeper than Karen Reed and far deeper than Aidan Kearney. And thank you, Marjorie, for your Cash App, who says thank you for standing up for Aidan. I have always been on the side of Aidan, on the side of free speech. And it has become more and more clear that they have been framing him. Framing him, not framing him. Kathleen, thank you for your Venmo. Says, in case you didn't see, reply, Judge O'Shea assigned to Karen Reed civil case, Plymouth Superior, Brockton, 100%. I don't know. I don't know that I saw that. I thought it was like, is that the same judge that's been assigned all along? I never thought it was going to be transferred to Judge Cannoni, Kathleen. Thank you for your Venmo, but I'm not really sure if it's been transferred to another judge. So Brian Walshe is not going to be appearing for this case because he's going to be on by Zoom. So it could be very short. Not really sure. Everyone, please remember to hit the like button. Let me just see. I want to see one more thing here before we move on to the next topic at hand. That is with regard to the Myles King case. And so what I wanted to do is a lot of people might not know about the Myles King case, which really should be called, the Marquis Simmons case, because it should be about the victim, and yet it's not. And if this guy gets off because Proctor screwed up again, as did Lally, you're going to have a guy who's already out on bail, because although he's charged with first-degree murder in the death of Marquis Simmons because he allegedly shot him in Milton when he got off of a moped all the way back in, I think it was 2021. Hang on one second. I want us to get familiar with the case, and I want us to get familiar with Marquis Simmons and how this is going to be a really big problem. He's been let out on bail because the trial was taking so damn long. Hang on. So this goes all the way back to 2021, July of 2021. Let me put on the subtitles for you. This is a minute and 30 seconds. Loved ones mourn the death of Marquis Simmons in Milton. 1 minute.
Police in Milton have made an arrest in the murder of a man who had just climbed off his moped outside his home. This happened just after 6 last night on Belvoir Road in Milton. Late this afternoon, police announced the arrest of a 21-year-old suspect. Here's WBZ's Tiffany Chan.
The arrest does bring this family some comfort. I spoke with the shooting victim's mother. She says out of everything, she'd like people to remember her son for his caring spirit. A family grieving. Loved ones of Marquis Simmons could be seen embracing one another, lighting candles in honor of the 25-year-old who was gunned down in Milton Saturday evening. We love you! The family released balloons where the violence unfolded steps from their home along Belvoir Road. The suspect, 21-year-old Myles King, was arrested Sunday, less than a day after the deadly shooting. The Norfolk District Attorney's Office says Simmons was getting off of his moped when he was shot from just a few yards away. Even neighbors looked on, mourning alongside this family and praying for justice. The shooting suspect, Myles King, will be arraigned on those murder charges in Quincy District Court on Monday. From Milton, I'm Tiffany Chan for WBZ News.
That was July 2021.
We're hoping to learn more at this morning's arraignment when the suspect, 21-year-old Myles King, is going to face that murder charge here at Quincy District Court. Now, this was the scene Saturday night at Belvoir Road in Milton. Investigators say the victim, 25-year-old Marquis Simmons, was on a moped when he got off and was shot just around the corner from his home. Simmons was taken to the hospital for emergency surgery, where he later died. Yesterday afternoon, police arrested Myles King on a murder warrant. And the district attorney's office says this murder was not random, but are not releasing any other details at this time. We're live outside Quincy District Court. Matt Reed, WCBB News Center 5.
And also it was released that on his deathbed, Marquis Simmons named Myles King as the shooter.
Today, through court documents, we learned that the victim and the suspect in this case knew each other and that they had problems going back more than 2 years.
Mr. King, the state police alleged that on July 10th of this year, he committed the offense of murder.
21-year-old Myles King was charged with killing his one-time friend, Marquis Simmons.
Why you have to let me down?
King may be better known in the rap world as Mizzie Ca, an aspiring Boston rapper with many YouTube videos displaying his music, some glamorizing weapons and money. But prosecutors say on Saturday night outside Simmons' home, it was King who approached Simmons and shot him in the chest. Simmons would later identify King to investigators before he died at Boston.
So he identified the shooter. There's Marquis Simmons. He's the victim. It's got to be about the victim, right? So sad. And I think it came out that 2 years before that, he was up on charges for sitting in a car with a loaded weapon outside Marquis' house.
Boston Medical Center Saturday night.
There's two victims.
Take that back a sec.
It's King who approached Simmons and shot him in the chest. Simmons would later identify King to investigators before he died at Boston Medical Center Saturday night.
There's two victims, the guy that's being charged and the young man that lost his life. So there's no winners in this case.
Young man with not enough structure in his life, and he didn't realize the consequences of taking another man's life.
Outside today's arraignment, Marquis Simmons' family and friends talked about how Myles King was arrested 2 years ago in front of their Milton home, sitting in a stolen car with a loaded weapon, the same location as Saturday night's shooting. They claim King had a vendetta against Marquis Simmons. Both were in the music business, but friends say Marquis was helpful to any upcoming artist.
As a person, he was a really happy kid. He was really energetic. He was always positive person. He was always trying to, keep everybody in good spirits. So we just, it hit us hard.
Myles King was ordered held without bail until his next court appearance in August. As for Marquis Simmons, we're told his funeral services will be held next weekend. Reporting live in Milton, I'm Ted Wayman, WCVB News Center 5.
Yes, Michael Proctor has been off duty from the state police since shortly after Karen Reed's first trial here last year. And he was fired from the state police.
Okay, so this was just published the day that Michael Proctor skipped the hearing. So this was 10 days ago, July 21st, 2025. The first three pieces I showed were around the original arrest of Myles King. This is the reports from the hearing that Proctor didn't show up at, that we watched together.
Yes, Michael Proctor has been off duty from the state police since shortly after Karen Reed's first trial here last year. And he was fired from the state police earlier this year. But at the time he left the force, he had a hand in dozens of ongoing investigations.
My understanding that former Trooper Proctor is not here.
Former State Trooper Michael Proctor was a no-show at this hearing. For two defendants he investigated in connection to a murder in Milton in 2021. Attorneys for Myles King and Brianna Gardner accused Proctor and prosecutors of dragging their feet when it comes to sharing evidence in their case.
So here's Rosemary Scapicchio. She's a pistol. She was in trial 4. If any of you saw that documentary, I think it's on Netflix. It's a couple of years old. I haven't watched it, but a lot of you pointed it out to me. And there's a lot of things I think Proctor does not want to testify to. That's the motion that we just read. So here's what Rosemary said after court, or Ms. Scapicchio, 10 days ago.
Defense attorney says she subpoenaed Proctor to be here.
Apparently he thinks he's above the law. So he was served in hand. He was told to be here this morning. Instead, his attorney showed up and said he left on vacation on Saturday. The vacation was planned, I understand, a year before.
Assistant District Attorney Adam Lally, who was one of the prosecutors on the Karen Reed case, did testify at the hearing. Last month, Reed was found not guilty of murder and manslaughter in the death of John O'Keefe. Lally testified he had repeatedly asked Proctor for search warrant material in connection to the King and Gardner case, but didn't receive it.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Objection. Overruled.
This judge is overruling the objections. Do you think this judge is going to allow Proctor to limit his testimony to only the King case? I don't. He's making Lally answer questions about other cases that he did this in, and it's all going to be relevant because it shows a pattern of conduct.
Not that I recall, no.
Now, this hearing will resume on August 5th, and by then, Proctor's attorney says he will be back from vacation and able to attend. Now, the defendants here and several others are also trying to obtain emails and text messages from Proctor to see if he wrote similar things about them as he wrote about Karen Reed. Live in Dedham, David Bieniek, WCVB News Center 5.
Today, the lead prosecutor in the...
And this is another news piece from the same day.
First Karen Reed trial took the stand in a different murder case with ties to former state police investigator Michael Proctor.
ADA Adam Lally was questioned about how he handled evidence that was supposed to be shared with the Myles King defense team. Let's get to NBC 10's Oscar Margain live outside Norfolk County Superior Court in Dedham, where the Reed trial took place, you'll recall. Oscar, this is a name we all remember. What did he have to say?
Glenn, ADA Lally spent almost 2 hours being grilled on the stand here in court today. He was being asked why he didn't press Michael Proctor harder on turning over information, turning over evidence over to the defense team in the Myles King case. Norfolk County Assistant District Attorney Adam Lally in the hot seat Monday.
I didn't get all 6 search warrants from Drew Proctor.
You did not.
I did not.
Explaining his role in the investigation of Myles King, the man accused of the 2021 murder of Marquis Simmons in Milton. Lally was grilled by King's defense attorney Rosemary Scapicchio, who questioned why it was taking so long to share discovery evidence with the defense as required by law, including search warrants collected by former state trooper Michael Proctor.
I entrusted that whatever discovery I was requesting, I would get at some point in a timely fashion and then turn it over.
But you didn't get it. You asked for it 5 times. You didn't get it. You had to go see him. You have him right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
Scapicchio.
And don't you think it's going to be fair game to ask Michael Proctor, did you do that in any other cases? Why didn't you give him what he needed? Have you ever done that in any other cases? Of course it's fair game. This judge is not going to allow it. I know there's a Brian Walshe hearing, and we're going to be covering it as soon as it goes live, which is just about in like 2 minutes. I have the feed up, so don't worry. Don't worry. I'm on top of it, as always. Here we go.
Filed a motion to dismiss the King case, arguing that the DA's office isn't doing a proper job collecting and sharing evidence in a timely fashion.
It's
They never
so
do.
haphazard that I'm concerned for every defendant out there as to whether or not they're getting appropriate discovery through the Norfolk County District Attorney's Office.
Proctor was fired in March by the state police board for the mishandling of evidence and inappropriate behavior during the Karen Reed investigation.
Was the Karen Reed case a one-off? And I would say it doesn't appear to be, because here we are again with late discovery.
Judge Peter Krupp ordered Scapicchio and the Commonwealth to hash out discrepancies in the discovery, but a larger Proctor issue.
There's Judge Krupp, and he's not having any of it. And is this the anti-Proctor sentiment that the media is spewing, according to Proctor's lawyer? Listen up.
Remains. Scapicchio hashed out discrepancies in the discovery, but a larger Proctor issue remains. Scapicchio and other defense attorneys rushed to court last week to prevent the scheduled destruction of Proctor's cloud data obtained by the FBI during the Reed case. Data they say could impact dozens of criminal cases he was tied to.
There wasn't anything he didn't have his hand in.
Now,
Wasn't
Proctor
anything he
was
didn't have his
summoned
hand
to
in.
court today, but he was a no-show. His lawyer said he will be present to testify on August 5th. That is when ADA Lally is also expected to finish his testimony. Reporting live in Dedham, Oscar Margain, NBC 10 Boston.
ABC attorney ADA Lally, Lolly. That's how they pronounce it. This is the Brian Walshe hearing that we're going to be watching next. And she got the hairdo of Guy Fieri, that's for sure. But she's a pistol. Isn't she? She is. I don't think Judge Krupp is going to stand for it. So this is today's Brian Walshe hearing. We're going to pivot to that live, and then we still have a lot of more things to talk about. So get some popcorn, get a drink, stay hydrated, because there's a lot of things on the agenda for today. And who knows what's going to pop up, because today's Friday. So a lot of things might pop up also while we're here. And we're here for all of it. I think, let me just check the docket. I think this is on for a motion hearing today. Talk amongst yourselves for a second. Talk amongst yourselves. Yes, this is a motion hearing. Larry Tipton, as we know, represents defendant Brian Walshe. He is the attorney, the public defender, who also defended Penny McGee in front of a bench trial with Judge Cannoni. And she was acquitted. There's no volume yet, so I don't think it's not us, it's them. And as always, if their volume stinks, I will turn my volume down and we will modulate, because we try and We try to accommodate everybody, but we can't always. You might want to grab your earbuds. And this is the feed from NBC 10. This is the NBC 10's feed, not the original Zoom feed. When it starts, we'll enlarge it again. I don't know. It's not my turn to. When is Turtle Boy back from vacation? I don't know. It's not my turn to watch him. We used to say in my family whenever anybody would say, "Where's so and so? Where's so and so?" I don't know. It's not my turn to watch him. Yes. Can we take a moment to appreciate? Oh, okay, good. Is Court TV handling it too? Good. That might be a better feed. Hang on, because they might have the camera in the courtroom. Thank you. Love you. But it looks like it's not going to be on Court TV's YouTube. It's only on their actual website. And the problem with their website is that they stop and they break it up and they comment on it. And we don't need to hear their commentary. Why did the court offices look like they were frozen in the back there? Somebody said that Aidan will be back to do his show tomorrow night. I do not know. I do not know about that. Can I confirm or deny? King Crab says, they never expected Karen and Aidan would be an issue. I can't believe the corrupt police are being rehomed and no repercussions to the guilty. Some investigation is still ongoing, so I think we still have to wait. Thanks for your super chat. Music to my soul. After Proctor was a no-show in the last hearing without notice, the judge may not be interested in entertaining his concerns about scope at this point. Good point. Good point. Music to my soul. Pretty Saint, thanks for becoming a member. Tony Canton, I can't quit you. Thanks, Mel, for staying with us. It's always been O'Shea, by the way. Yes, okay, it's always been O'Shea. There's another judge named O'Malley in another case, and so I'm getting my Irish judges confused. And I think I don't know how they do their civil cases. If it's anything like their criminal cases, there's a different judge every hearing. It's like everyone's on Zoom. This is Larry Tipton on the left.
Just want to make sure that we have Mr. Walsh here. Has he been brought in? No.
Oh, here's.
I did. Salt and vinegar. I felt buffalo. So good, but I don't buffalo. Yeah.
People need to mute if they're on the Zoom.
I wish it was. I need you to mute yourselves. Anyone on Zoom needs to mute themselves.
Brian Walshe will be in the bottom box.
All right. Judge Freniere will be out in just a moment.
This is going to be Judge Freniere.
I just need 1 second.
There's Brian Walshe in his orange jumpsuit. And there he is with his hammer haircut. LC the barber. Aidan Kearney told us that when he was in the Norfolk County Pokey, so was Brian Walshe. LC is the barber. I didn't realize LC was also An inmate. Looks like he got his hair cut with a hammer and or had a fight with a lawnmower and lost. I'm not sure what motion they're arguing today, but we're here for it. And hopefully the volume's going to get a little bit better. Can you guys hear it okay? Hi, Kelly. Good question. If Proctor doesn't have the missing warrants and the DA's office doesn't, what happens with the case? Proctor is just saying that because he no longer has access to the file, he can't bring them with him. And the subpoena says, bring all your documents with you that you have. He's saying, I don't have them, but I do think they are somewhere in the file. But that's a great question, Kelly. Could be evidence that is suppressed. They're somewhere. Proctor just says he doesn't have access to the file anymore, and so he can't get his hands on them. It's very super chat. If you're not at your screen and you're not driving or on scaffolding, come look at Brian Walshe's hammer haircut. I think Aidan said that LC was transferred, though, out of the Norfolk County Pokey, and so he can no longer give the $5 haircuts. And it's a very good example of sometimes you get what you pay for. A $5 haircut is a $5 haircut. Nobody's talking right now. They're waiting for the judge. Yeah. Maybe Chloe ate the warrants, says Scott McGinnis. Innocent until proven guilty, as always. However, the Google search is made by Brian Walshe's son's iPad, which are now going to be allowed into evidence based on the judge's ruling that we read recently, even though it was outside the scope of the consent warrant, in my opinion. Could be very good circumstantial evidence that he may be guilty of something, at least after the fact, with regard to Anna Walsh's body, but the body has never been found, as you know. It does look like he's in the chat. It's a little freaky. It's a little freaky. Not gonna lie. Aidan said that he put a note, I think, under Brian Walshe's cell door or something when they were in the Pokey. I can't remember the details exactly. I'm summarizing, and said something like, "Hi, I'm Aidan Kearney. If you'd like to talk, I'd like to talk to you." And then I think that Brian Walshe wrote him a really nice note back saying, "Thank you so much for writing to me, but I don't know, maybe my lawyer said I'm not allowed to talk to anybody, or I can't talk to anybody, or..." So that's interesting. Irish Rover says, so innocent until proven guilty, but you lock the person up to make them wait for someone to prove them guilty seems rather prejudgmental. Well, he's charged with first-degree murder, and I don't think there's bail available for that. But you know what? So is Myles King. And now Myles King is out because it took so long for his trial to happen. I believe that's why he got out on bail. If anybody knows, let me know. But they held him in there for a long time. It's a 2021 case. Myles King has been in custody since 2021. Brian looks like my co-host. Oh, no. Welcome to today's live stream. And without further ado, I'd like to introduce you to my co-host for today, Brian Walshe. It'd be funny if we did this. Oops, we can't do that because that didn't work. Never mind. I was going to try and put us side by side like he really was my co-host. Oh, he's really looking at us. He's looking into our souls. It's a little freaky. Do they get YouTube in the Pokey? Brian, are you watching? Hey, Brian, what's up? Listen, just because you sold a couple of maybe Andy Warhol fakes on eBay doesn't necessarily make you a murderer, right? Somebody else could have had your son's iPad. In fact, I want to know whose Apple ID your son's iPad was logged into. Because if it was Anna's, what if it's a Gone Girl situation? And Anna is gone, but she was somewhere far away with her lover. Googling those things to frame you, Brian Walshe. But allegedly, they found a bone fragment on a hacksaw in a dumpster. But I don't know if the bone fragment's ever been tested. So there's a lot that I want to know from you, Brian. I want to know those things. Why? Why were you at Home Depot buying mops and buckets and all of those 20 different kinds of hydrogen? I didn't even know there were 20 different kinds of hydrogen peroxide. Brian, allegedly. Where was your mother on the night of January 1st, 2023? In the early morning hours. None of his Google searches, I just want to point out to you, actually queried how to a person. They all had to do with cleaning up afterwards and disposing of the remains. And so I don't think they go to premeditation as much as they may go to what happened after the fact. Libby says, I think Anna was plotting. The bone has never been tested. It could be a chicken wing bone. What? Really? What? Really? I mean, you know how the media likes to put out a false narrative about, you know, ring camera footage of the incident of Karen Reed hitting John O'Keefe with her car, because they did put that out right away. Jennifer says, who hires a psychic and a PI to get info on their daughter-in-law? Did she hire the PI before Anna went missing, like to see if she was having an affair? Or did she hire the PI after Anna went missing to try and find her? I have so many questions. And you may recall this was out of Cohasset. Okay.
Court's now in session. You be seated.
I may proceed, Your Honor. Yes. Thank you. The matter before the court is Commonwealth versus Brian Walshe on docket 2382CR0091. This is a Norfolk County Superior Court case. This is being recorded in Plymouth County Superior Court Room A. Mr. Walshe is present via Zoom, beginning with the Commonwealth. If you please take your names for the record. Hold on. All folks on Zoom, I need you to mute yourselves.
Okay. The person holding the Zoom meeting has the capability to mute all of the people that they want to and they need to. This is the pool camera in the courtroom, NBC 10, focusing on the Zoom screen inside the courtroom and sometimes on the judge. It's 2025, okay? Zoom became popular 5 years ago. Can we figure it out?
Anyone on Zoom, if you're not a party, you need to mute yourselves.
Especially if you're live streaming me, because then it makes it sound like I'm the one who's not muting and I'm using NBC 10's.
Madam Clerk, mute everybody.
We'll try it, then we won't really have.
I understand that. So if you mute everybody and then unmute Mr. Tipton, Ms. Yaz.
It won't allow me to.
Okay, we're going to switch to this because I think the sound's better. Let me know.
Well, importantly, Attorney Tipton is now muted. Greetings.
I'm trying to mute everyone except the parties. Hold on. So I did mute everyone. I muted everyone, but then I can't get the parties to unmute.
Well, yeah, because that mutes it through the system. No one will hear you.
Okay. Fine.
So if you
Boston 25 sound is better. We're going to stay here. Just wait until we get started before you start complaining, and then I'll lower my volume to even out with the court.
Muted. You are unmuted.
Yeah. They can't figure out how to mute all the people on the call.
they have to unmute on her side. It's not okay. So
Tell your friends that we're handling this so that they can come and watch with us. Because the title of the stream is about Proctor, but this is happening. And because the network is streaming it, I can stream it too. Because Mike Crawford got in trouble this morning.
For the record, Your Honor, Commonwealth versus Brian Walshe on 2382 CR0091. Mr. Walshe is present. Because everyone has now been muted except the parties, beginning with the Commonwealth. If you would please state your names for the record.
Good afternoon, Your Honor. Greg Connor for the Commonwealth. With me today is Tracy Cusick from my office, Gordon McLaughlin from my office, and Ann Yaz from my office.
Good afternoon, Your Honor. Alisa Beatty from the Commonwealth.
Good afternoon, Your Honor. Larry Tipton for Mr. Walsh, who's also on Zoom. Attorney Porges will not be here today.
All right, welcome to all the lawyers, and good afternoon, Mr. Walsh. So we were scheduled this afternoon to sort of hear an update on this issue. I want to alert sort of the defense to something, both parties to something. It could go either way, and see if people have any objection after consultation with your respective clients. It appears to me that there certainly could be an appearance of a conflict that I have vis-a-vis the Commonwealth's choice of attorney. That is, the Commonwealth has chosen attorney Michael Sullivan to represent them in connection with their dealings with the United States Attorney's Office. And that choice of an attorney is a mentor of mine and a friend of mine.
Did they do that on purpose so that the case could go back to Kearney? Kearney had this case before Freniere. We have the ability to pause here because it's on YouTube with Boston 25 and not on the website of Boston 10. Did they choose this guy on purpose, Michael Sullivan, because they knew Freniere would have a conflict? Let's keep listening.
And so it seems to me that although I have, as they say, searched my conscience to see whether I could make an objective decision, recognizing the nature of this decision in particular, I'm confident that I could be fair in any decision making. I also feel that it's appropriate to let the parties know that and for you to consult with your client. If in fact you prefer I not to resolve this issue relating to, we'll call it the federal materials, as a result of the fact that the Commonwealth has chosen an attorney who I formerly worked closely with, then seems to me that it might be best and most efficient for you to resolve this with Judge Krupp and with the other cases. So first, to the defense, do you wish to consult with your client about that, Attorney Tipton? In fact, I think you need to consult with your client about that.
Yep.
And or do you have any additional questions for me?
I don't have any additional questions right now, Judge. I would, yes, I would need to consult with Mr. Walsh.
All right. And based on the same, the Commonwealth has a perfect obligation to, right to say we don't like it either. But you can think about that. It seems like based on the minimal information that I got, I was expecting that the parties were going to say we need more time anyway. And so Judge Krupp has a hearing scheduled for the 5th. So if it turns out that either the parties aren't comfortable with me going forward, given what I've disclosed on this particular issue, and I don't think that it relates to any other issue in the case, then I'll send you off to Judge Krupp probably.
Yeah, he's hearing it on
There's
Tuesday
another
anyway.
judge here that could hear you in Plymouth County, but since Judge Krupp already has the issue before him in a series of other cases, that would seem to be the most efficient. Anybody else have any other ideas of where you go?
I'll break this down in a second.
I hear none. So why don't we do this? Attorney Tipton, I think that Madam Clerk can get everybody else off and allow you, if you wish, today to consult with your client on Zoom. I think we should just put this hearing off on this particular issue until next week, until you've had a time to adequately consider the issue. All right?
Yes, Judge. Yes, Your Honor.
Now, separate and apart from that, I realize that we don't, what, if any, other dates do we have?
What, if any?
Leading up to October 20th, other than the final trial conference?
We have our filing deadlines for motions in limine, Your Honor, and we have our final pretrial hearing, I believe, off the top of my head, I think it's October 9th to October 7th. Everyone in the room just corrected me. And so those are the next dates I think we appear in court is October 7th.
All right. Anybody see the need for any other interim date?
Judge, I think that we would be filing a motion for change of venue, but I think it can be handled in the normal course in the
Motion
final
eliminate.
pretrial.
Okay.
Oh, they're going to move
I'll
for change
look
of venue.
Along with obviously any other important, or they're all important motions eliminate. So, but if something comes up and you need to see the court, you know where to find me. Otherwise, I'll plan to see you in October. And that's presuming, we're just putting a pause on this issue that we're flagging right now until you've had a chance to decide how you want to handle that, all right?
Yes, sure. Yes, Your Honor.
All right. Thank you very much.
Thank you. Thank you.
Okay, I think they're going to cut it, but I'm going to explain to you what's happening. All right. She's saying she may have a conflict with respect to only this one issue, not with regard to the whole entire case. The one issue to which she is referring is, they're going to cut it, is this destruction of Michael Proctor's text messages and communications that were turned over by the feds in the Karen Reed case.
I thought she was talking about sending them to Rick.
And all of the attorneys in all of the collateral cases that Michael Proctor was an investigator in were just notified the day before the order. So here's what happened. The feds dumped, as you know, a whole bunch of stuff on the attorneys in Karen Reed. And they were like, here's a whole bunch of stuff. Some of it could be exculpatory. A lot of it had to do with Proctor's text messages and communications in the Karen Reed case. The attorneys in all of these other cases were just notified. That federal order, the original federal order, or the most recent federal order said 30 days after the conclusion of the Karen Reed case, all of those materials were to be destroyed. That would have meant that by July 18th, all of the Proctor federal materials that were turned over by the feds, the TUI materials, were supposed to be destroyed. All of the attorneys in these collateral cases, like the Myles King case, where we saw Rosemary Scapicchio, like the Brian Walshe case, and a couple of other cases, were told one day before that these materials were going to be destroyed. They ran into Judge Krupp and they said, we need you to extend this order because we don't know if any of this stuff could show bias against our clients. We don't know if this could be relevant in our cases. And so you need to put a stay on this so they don't destroy the materials. And so they did extend it for 30 days. And there is a hearing scheduled in front of Krupp next Tuesday, where he told all of the attorneys in these other cases, because remember, I watched that Zoom hearing myself and then reported back to you on what happened, that they're going to hear that motion on Tuesday, the 5th at noon during lunchtime, when there's a break in the Myles King hearing in which Lally has to come back, Proctor has to come back. And so Judge Freniere said just now, because she was coming back to revisit this same exact issue, the Commonwealth has hired a guy named Mike Sullivan, I think it's Mike Sullivan, to represent them in the destruction of these federal materials. And he was my mentor. And I think I may have a conflict. You can decide whether you think, I think I can be fair. This is what a judge is supposed to do. They're supposed to avoid even the appearance of impropriety. This is what a good judge does. And she said, I think, to be honest, as a judge should be, I could have a conflict because I know this guy, Michael Sullivan, the Commonwealth chose him. And so therefore, I'm going to let you talk to your client and decide whether you want me to recuse myself on this one issue. And she said, or you can just go in with the other parties in front of Judge Krupp on Tuesday at noon because he's hearing it anyway. And I think that's what they should do. I think that's what they should do. So she's not going to want to recuse herself from the whole entire Walshe case just for that one issue of the federal materials. Michael Sullivan is a former U.S. attorney for the District of Massachusetts. It's a position that he held for 8 years. And of course, the Commonwealth has chosen him, intentionally because Freniere would have a conflict. I don't know. But here's his bio. So let's take a look. That Michael Sullivan is a former U.S. attorney for the District of Massachusetts, a position he held for 8 years. He's an expert in government investigations, corporate compliance and ethics, fraud, corruption, healthcare, and corporate security, and has extensive policy and regulatory experience. So they went out and got the big guns to come in and defend the Commonwealth, maybe, or the feds on why these things should be destroyed. Are you surprised? I'm not. So it looks like we're going to have some motions in lemonade to look forward to on the Brian Walshe case. And then the pretrial conference is coming up on October 7th. So many cases, so little time. Don't drink the water in Norfolk County, by the way. And we heard Larry Tipton say that he may move for a change of venue on Brian Walshe. This judge, Freniere, who it was reassigned to after it was taken away from Judge Cannoni, sits in Plymouth Superior Court. But my understanding was this is a Norfolk case, and even though she sits in Plymouth, and there's 2 courts, I've learned, 2 superior courts in Plymouth, one in Brockton. She's in the Plymouth version, Plymouth building. And all the conferences have been there. But since it was a Norfolk County case, my understanding would be they need a Norfolk County jury, and so they would need to try it in Norfolk County. And so Larry Tipton has just said that they are going to potentially move for a change of venue, and that will be with one of the motions in lemonade that are going to be forthcoming. So we have so many things to look forward to in Norfolk County. It's like we can't even get out of Norfolk County because there's so many things to cover. As Gigi says, I would suggest and only suggest those in Massachusetts should not drink the tap water. Seems something is in there. Something's in the water. Moynihan reps spam from his website. Thank you, Camvat. I'm not sure what spam is. Amanj says, as always, I love your reporting on the papers and stories that need to be heard that no one will cover. This judge will not let Proctor off easy. I don't think so either. I think Crop G, Officer Crop G. Remember that from West Side Story? Crop U. I don't think Judge Krupp is going to limit his testimony either. I think Judge Krupp is probably as curious as we are about all of the things that Proctor has done in so many other cases. All the cases. Strains credulity says Proctor's appeal was built on a house of cards on fire. But surely this Myles King case just added petrol to that. Yeah. Yeah. I mean, do you think Michael Proctor is going to be reinstated? especially after Laura McLaughlin said in open court in the Walshe hearing or in the papers that there was stuff in Proctor's text messages or communications that could be exculpatory to Brian Walshe. It's a problem. New name for Lally, Skippy, says Gigi. Helena says, I love Friday night at Melanie's. Thank you. Well, you're in Sweden, so it's nighttime for you. Thanks, Helena. eBay Warhol, off topic. Crazy question. Is it possible the Commonwealth doesn't want to return Karen Read stuff because they can't find it? We know evidence logs mean nothing. Well, I mean, it would be hard to lose the car, right? The phones, apparently, my first thought was that perhaps Karen's attorneys would be able to use experts to find out that the Commonwealth and or law enforcement in the Karen Read case tampered with the evidence. That's possible. But now that Cosgrove has just told us that there seems to be an ongoing investigation, could that be the reason that they don't want to return her other phones that were seized when they tried to indict Aidan Kearney and Karen Read for conspiracy to commit witness intimidation all the way back in something like March or April of 2024 before the first trial, and the grand jury did not return a true bill and did not indict. So that's not a crazy question. I don't think they can't find it. I think they have a reason why they don't want to turn it over, because you should not have to make a motion, by the way, to get your client's property back. You shouldn't have to make a motion. It should be a phone call and they should just release it. And so the fact that they have to jump through these hoops by making motions and continue to cause Karen Read to incur more expenses after her acquittal is mind-numbing to any attorney who practices in Massachusetts and other places, because I spoke with Tom Kokonowski on this, who is a Massachusetts attorney who represented Brian Camp. And he said in over 30 years of practice in Massachusetts, he has never had to make a motion to have his client's property returned after an acquittal and or the case was over. And it's also important to point out that Karen Read's cell phone was not entered into evidence in the Karen Read case. It's not like it was part of the evidence. Maybe the extractions were, maybe the experts testified about the extractions, but the actual phone itself was never entered into evidence. So that's not a reason to hang on to it, that for some reason they got to, like, I don't know, jump through some hoops to get it out of evidence. I don't know. The whole thing is crazy, Tracy, and I just don't know what to tell you. Gigi, can you imagine how much we would save on clothes and shoes if we could just work from our kitchen, bathroom, dining room, etc., and never walk into a courtroom, pay for parking, blah, blah, blah? Sad. Yes, well, you know, a lot of things are done on Zoom now. And here in New York, too. Like, there's a lot of appearances lawyers don't have to make anymore. So dressing from the waist up is still a thing. It is, but wouldn't it be great if everything was like that? Thanks, Gigi, for your 10. Michelle says I'm late, but what type of motion hearing is this? Well, this was the motion on the federal materials being destroyed after the Karen Read case. So I'm a little behind on this, so perhaps you figured it out. Thanks, Michelle. Chief says, I think LC trained the new jailhouse barber. You might be right. You might be right. Sue says, hello from Saratoga Springs. Oh, yeah, up there for the ponies. Maybe Brian can log in from his state-issued iPad. Maybe. Have a great time, Suze. And if you have any horses running up there, I hope they win. Bridget, I can clean his hair up. All right, Bridget Pike is well, I don't know. Do you really want to go to Norfolk County Pokey and do a little trim on the guy? I mean, it was kind of, it looked like he washed his hair in the prison toilet with the toilet hooch. I mean, listen, it's a joke, right? Remember Sarah Boone used to make toilet hooch? She was talking about making, like, they make alcohol in the toilets, in the prison toilets, and it's real. It's a real thing. It happens. They ferment the fruit in there because, they can't get regular hooch. Oh, Gigi gifted another 10. Look at all these new members coming. Mrs. Jim Morrison, you got a membership. Jazia says, Anna is gone, in my opinion, to the Endless Heaven buffet. Yeah, that is, I have to give credit where credit is due to Kathy of Gossip, Rumor, and Innuendo. for coining that phrase, the endless heaven buffet. I don't know. I don't know. I mean, look, if somebody was setting him up and had access to that iPad or made searches under another Apple ID and they showed up on that iPad populated, and, that was a chicken bone on that. So, but again, he is on video, like buying all of those things to clean it up. That doesn't necessarily mean that he did the actual deed, right? It could mean that he disposed of the body afterwards, but maybe it was an accident. Maybe somebody else did it. Maybe, I don't know. But yeah, I don't know if she's gone or not gone, but innocent until proven guilty, right? Thanks for your super chat. For the love of the traveling trooper, an entire day with Melanie and the cupcakes. Happy. Oh, thanks. Thanks for being here. She's got this little bracelet already. Said, I see they use leaf blowers to style their hair too. Yeah, leaf blowers and hammers or lawnmowers. Thanks, Gigi, for all your super chats today. Skybell says we are still living in the land of the lost. We are. But now that Michael Proctor has made a motion, sometimes we put Michael Proctor up in the corner because, he's like the patron devil of the Karen Reed case. And then that was the old picture. And then we had to update it because he had quite a glow down. I'm sorry, but he did have a glow down. Whereas Jennifer McCabe had a glow up between season 1 and season 2, Proctor has had a glow down. And he was not called to testify in season 2, but we did get to see him on TV give this interview. And that is where it's from. And then sometimes we put Dexter up in the corner because if you know, you know. Sometimes people need killing. Like the victim in the Aaron Spencer case. Thank you, Skybell, for your super chat. Shooty UK says, is this similar to having Brennan brought in? I pity the poor taxpayers having to pay for these big guns. Well, if he's in private practice, they're hiring him as a special something. And I can't recall exactly what she said now, whether it was the Commonwealth has hired him. She said the Commonwealth has hired him, right? So it wasn't like he's being hired by the U.S. Attorney's Office. It's like he's being hired by the Commonwealth. So yes, another special prosecutor. And why? Is there a conflict? Is anybody asking Morrissey the tough question? I need proof of life on Morrissey. Has Morrissey spoken to any reporters since Karen Reed's acquittal? Has anybody knocked on his door? Has he shown his face at all outside of maybe a July 4th parade somewhere? Has any attorney tried to ask him any questions? I don't think so. But I think if you live in Norfolk County, you deserve answers. You deserve answers about why now they have to hire another special prosecutor. Gigi gifted another 10 memberships. You are so generous all the time, every single time. And Kay Willis is here. Thank you, Gigi. And she gifted 5 memberships, and she is a realtor south of Boston. So if you want to get the hell out of there, Kay Willis is your girl. Thanks, Kay. Thanks, Gigi, for your very generous gifting of so many members today. Cambat1 says spam is State Police Association of Massachusetts. Moynihan represents them. Thank you. So he is like a union attorney. So is the union paying for Proctor's attorney to file this motion? Thank you for clarifying that because I was confused. Steve F says prison haircuts are right up there with prison meatloaf, in my opinion. Aidan Kearney did say on several streams of interviews that people did with him that he did enjoy the prison or the jailhouse chili, and that he never liked chili before, but he did like the chili in the Norfolk County pokey, right? So that's interesting to me. Hopefully one of the mainstream media companies is going to pick up the hearing on Tuesday, because we've been warned by the judge this morning in whatever county that was, Attleboro, that we're not allowed to, or nobody's allowed to, live stream the Zooms. So listen to this, because now apparently you guys are telling me that Mike Crawford has put up a show that he's going to do at 3, that he's been threatened with sanctions for trying to live stream Lindsey Gaetani's hearing this morning. So apparently you can watch it yourself and then report on it, but you're not allowed to live stream it. So I'm going to repeat to you, because I screen recorded it, because he took down the video, what the judge actually said. So hold please while I turn this on. Her name is Judge Michelle. Looks like Amour, A-R-M-O-U-R. I can't, hold on.
Pursuant to the SJC Rule 1.
Okay, hold on. She says they put up the Zoom and they've got Lindsey Gaetani and her attorney are standing in front of the podium. And there's another guy on there, like on his couch. Like, I don't know who he is because his name is not on the screen. And then there's another wide shot of the courtroom. And then there's the judge who has a short blonde bob and glasses. And here's what she says. I'm just going to repeat what she says to you. Hold on. And Kate Peter has admitted to reporting. Hi, good morning. This is the first session of the Attleboro District Court. I have to put it on a slow speed so I can repeat it better to you. Oh, I don't know if I can do that way. Hold, please. No, you can't hear the audio. You can't hear anything because they don't want you to see anything or hear anything.
Hi, good morning. This is the first session of the Attleboro District Court.
Hi, good morning. This is the first session of the Attleboro District Court. It has come to my attention this morning that there are some individuals who are attempting to live stream this event and record this event without prior approval or permission from the Attleboro District Court. No, I can't put it up to the mic. I can't. Do you want me to get in trouble too? Do you want me to get sanctions? I'm reporting on it like a reporter would by simply repeating it to you. That's what I'm doing. Okay. Pursuant to the SJ Rule 119, in order for anyone to photograph, record, or live stream this proceeding, they needed prior approval of the court, given prior approval to certain individuals. How could you hear it? It's so low. It's so low in my ear. Okay. But I'm going to have to get my earbuds. Hang on. We've given permission to certain individuals in advance of the proceeding today. If you have not been given prior approval, you are prohibited from taking any photographs or anything. And then she said, I see that there's still some of you. Oh, is it on speaker? There are still some of you that are trying to live stream this. And because of that, I'm going to cut you off and you're going to get in trouble. And then Mike Crawford was cut off from the stream. And then apparently now he's been threatened. So he put up a show, I think, for 3 o'clock. And there's that. And then she said something like, there's FTR and you can order transcripts, but that costs money. So that means the public can't really know about it because you have to pay for the transcripts. And hang on one second. Kate Peter is the one who is now admitting that she is the one who reported the Young Jurks for trying to get Lindsey's hearing and live stream it. So you can listen to it, but you're not supposed to rebroadcast it. So everyone now is going to have to get on the Zoom. But here's the thing, because we know this, because I've tried to get on Zooms before, and then they just like, anyone can listen on Zoom, says Massdad, and FTR is only $10 a day for the audio. Oh, okay. So you can get it for $10 a day. But do you have to have an FTR account? I don't know how that works. I don't know how that works. I bet you have to order it, and then it takes time for it to be transcribed, right? What a surprise. That was Kate Peter. Lindsey was in the chat the other day. If you weren't here for that, she might be here still. She didn't want anybody knowing what happened. But I can report on what happened. So let me tell you what happened. If you weren't here earlier. I don't even really know. Do you guys, can somebody tell me what the actual charges were? She was, is this the one where she threatened someone's life and threatened to kill her and her children or something like that? Hang on. Apparently, she's taken a plea agreement today, Lindsey Gaetani, and is on 6 months of probation with the requirement to complete anger management classes. She also agreed to a stay-away order from the victim and her family. And if the stay-away order is broken, she faces 6 months in the pokey. So there's that. Glamasu says, yes, she threatened Mary. Okay, so the victim's name is Mary, to unalive her and her children. Interesting. Kristen says, I'm so sick of all these unnecessary delays. This doesn't happen in cases around the country. It does, though. It does. There's a lot of delays everywhere. Everywhere there's delays. Everywhere. I don't know which case you're specifically talking about, but there's delays everywhere. So apparently it's up to the judge. It's up to the judge. You're not allowed to covertly photograph or record anything. Electronic access to the court. I thought she said 1.13. These delays are everywhere. It's not uncommon. It happens all the time. Shanna Gardner just got pushed back a year. Wow. I started covering that case in the beginning and then there was nothing happening. And then I saw there was just a hearing on it. Like it's in Florida, right? Like yesterday. And I was going to say, do you guys want to watch that hearing? And I started watching it and the audio was bad. You think today's audio was bad? That was really bad. And it just got pushed back a year. That's in the murder for hire of Jared Bridegan, which is a story that I was really interested in. And so thank you, Kate, for letting me know. But Myles King has been waiting so long. I saw this and I thought that said Joan Baez. And I'm like, Joan Baez is defending Shannon Gardner? Jose Baez. She comes from a very, very wealthy family, Shannon Gardner. Her parents are very, 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 very wealthy. So they can afford the best. And they got it. The only crust I trust is pizza crust. You know what, Helena? Don't even trust your pizza crust, because pizza crust and the DNA or saliva on said pizza crust is one of the things that caught Rex Heuermann, the suspected Long Island serial killer, because they picked a piece of pizza crust out of the garbage that Rex Heuermann had bitten, and that's how they got his DNA. So don't even trust your pizza crust at this point. All right. In other news, Victoria George has withdrawn or filed a motion to withdraw or a notice of withdrawal from the Karen Reed case, which is not unusual either, because her duties were over. Okay, why? And she apparently still works for David Yanetti's firm, or maybe she was just on a contract basis working for David Yanetti's firm. So I'm not really sure. I will be going to Rex Heuermann's trial, but that is going to be a long time, a long way away. There will be no cameras in the courtroom in that, because it's a New York case. And so I'm going to have to go, which is fine with me. I'll go, but it's a long way off. It's a long way off, because they're still arguing about this new DNA technology that they use to identify the hairs and stuff. Yeah, I have a lot of stuff on this Mick Patel. Somebody reached out to me, Mahendra Patel. He is a Walmart worker who is going on trial for attempted kidnapping, because there was a woman like on a scooter with carrying her kids, and she like lost her grip on the baby, and the Walmart worker, Mr. Patel, went over to grab the baby from falling off of the scooter, and he's being charged with kidnapping. And this woman apparently has accused other people of other things also. And so I have stuff on that. I just haven't had a chance to look at it yet, but I will. Thank you, Rolling Stone, for coming in with all caps to tell me that affidavit of counsel in support of defendant Karen Reed's motion for relief from the April 10th order to impound sidebar is in. Well, it could be it could be docketed, but not yet scanned. It's not in my inbox. I don't have it. Let me do one thing at a time, eh? May I? Mother, may I? Thank you, Sarah, for your Venmo. Says, can they just keep Karen's phone without a search warrant on a different case? No, they're not supposed to. They're not supposed to keep anything. If that resulted in they didn't indict her on Aidan's case, that's been over for a long time, for at least a year and a half. They should turn it back over. And the phone's been extracted, so there's no reason for them to hang on to the physical phone itself, right? He didn't work for Walmart? I thought he worked for Walmart. I thought he was a worker at whatever store it was. Whatever store it was in, I thought he was a worker there. That's the information that I got. He was asking the mother if she knew where the Tylenol was. All right, I'm gonna have to look at my notes. So don't hate me because I just haven't looked at it yet. But I will, if you want me to. If you want to cover it, we can cover it. Steven says, another thought. Why do you think a retired judge is prosecuting Aidan Kearney? Maybe to help protect the corruption that he was or is a part of? I don't know. Ken Mello was the original, the OG. And then, I don't know, maybe they couldn't find anybody else. But that, Steven, listen, your guess is as good as anyone's, I guess, at this point, right? So Victoria George made a motion to withdraw as counsel. That was filed yesterday. Take a look at that. People think she lost they lost Karen's phone. The Can Leaf Blower Society has decided to convene outside my window. And that is here. Motion to withdraw as counsel. Now comes Victoria B. George, respectfully move this honorable court to withdraw as counsel in the above captioned matter. In support of this motion, counsel states as follows. Number one, counsel's representation of the defendant was limited to her trial. Number two, the defendant's trial concluded on June 18th, 2025, and judgment has been entered. So they were waiting for it to be entered. I think it was just entered like yesterday. Three, counsel notified the defendant in writing on June 23rd, 2025, that she no longer represents the defendant and is not involved with her probation proceedings. Four, withdrawal will not prejudice the defendant who's currently represented by other counsel. Five, in connection with this withdrawal, counsel also respectfully moves to withdraw as Pro Hoc Vice sponsor for any out-of-state attorneys admitted in this or any related matters. This withdrawal will not prejudice the defendant as she is currently represented by other local counsel who are serving or who are able to serve as Pro Hoc Vice sponsors. And that's true. We've seen some other attorneys who are Massachusetts admitted file some papers in this matter very recently. And wherefore, counsel respectfully request this honorable court allow this motion to withdraw as counsel and as Pro Hoc Vice sponsor in this matter, XOXO, Victoria George, United Criminal Defense Firm. There's her BBO number. And that was filed just yesterday, July 31st. Very common. and nothing crazy. I don't know if she still works with the Yanetti's firm. I have no idea. I know she has 4 kids. I think 4 kids under 4 or something crazy like that. She was pregnant with twins during the first Karen Reed trial when she was picked as an alternate juror. And then they hired her to come on for, I think, jury selection, or who knows what she was doing behind the scenes. But apparently she is asking to withdraw. That should just be granted automatically, rubber stamped. But who the hell knows what goes on in Massachusetts? Not me. In other news, the Matthew Farwell hearing has been pushed to October 15th of 2025. There's supposed to be a hearing upcoming very soon, I think next week. And nothing's been filed in Matthew Farwell's case. He, you may know, is being held in the federal system, awaiting murder charges on Sandra Birchmore in the federal courts. And they keep pushing his hearing and pushing his hearing and pushing his hearing, and nothing's been filed and nothing's happening. And it's infuriating for everyone who wants to see justice for Sandra Birchmore, right? This to me. Are you outraged yet? Hold, please. Something else I want to share with you was the Boston Globe article about Aidan Kearney and Ben Affleck, which we found interesting. Haven't seen this. Take a look at this. People got the comments against the Boston Globe are go for the comments. If you have a subscription to the Globe, go for the comments because people are mad that they picked up the story. And this is from yesterday morning. Is Ben playing Turtle Boy in the movie deal? Ben Affleck and Karen Reed backer hung out and people noticed. Really, Boston Globe. By Travis Anderson, updated yesterday at 10:12 a.m. Here's a picture of Aidan with his arms up. Outside, right after the acquittal. Aidan Kearney, after the jury acquitted Karen Reed in June. Let's go into reader view so we don't have to. Kearney said his young son and daughter had no idea who Affleck was. Here's some photos of Ben Affleck in various roles that he's been in. Oh, and Geely, remember that? Ben Affleck and Jennifer Lopez. I think that's where they first met. Thank God he got her off his back. My God, what an albatross. What an albatross, right. The Globe didn't cover anything about Karen Reed until the second trial, says Tony, but this is news. Get out of here. Yep. Remember Geely? Jiggly or Gigli? That was a movie that bombed with Ben Affleck and J-Lo. And then there's a picture of him with Matt Damon in Good Will Hunting, one of my favorite movies. Shenanigans, Tomfoolery, and Ballyhoo is from that movie, Good Will Hunting. Batman in Justice League, and there he is with Jeremy Renner in The Town. Turtle Boy has said on my show that he would like Jeremy Renner to actually play him, which now this is interesting because if there's any truth to any of this wild speculation that Ben Affleck maybe somehow, I don't know, maybe directing, he couldn't star as Aidan, let's face it, they're quite different height-wise, but look, here's a picture of Ben Affleck and Jeremy Renner in The Town. Now, Ben Affleck has ties to Jeremy Renner. Jeremy Renner is who Aidan Kearney would like to play him in the movie. So, could it be that by happenstance they met in a pizzeria and Aidan said, hey, Ben, do you want to direct my movie? Because you have ties to Jeremy Renner and I really would like him to play me. That is interesting. I just put that together while I was reading this to you. Because, you know, if we're going to wildly speculate about stuff, Boston Globe, let's really go. Let's really go with it. But here's Jeremy Renner. So what do you think? I mean, that's a good choice for Aidan. Okay. Shelley says, Jeremy Renner is my hall pass. And there he is in, there's Ben Affleck in Argo, and then with Joey Lauren Adams in Chasing Amy. Chasing Amy. I remember that movie a long time ago. The Boston Globe goes on to say, the post from Kearney, who gained a huge following by championing Reed's assertions of innocence in her murder case, set the internet ablaze, fueling speculation that the actor, beloved for performances in Good Will Hunting and The Town, may have had a tell your people to call my people moment with the pugnacious blogger. Soon after Reed's June acquittal on charges of killing her boyfriend, The Hollywood Reporter said the former financial analyst and her lead attorney, Alan Jackson, were partnering with LBI Productions to work on a scripted project based on the high-profile case. When Kearney dropped his photo montage online, conjecture about Affleck's possible involvement reached a fever pitch. And then it says in parentheses, Affleck's handlers have offered no confirmation to the trade publications. Big Ben, one person replied to Kearney. Him and Matt Damon should come back together to do your movie. Matt could definitely play a turtle boy. Ben can be Alan Jackson. Another wondered, is Ben playing turtle boy in the movie deal? Reed, 45, was acquitted of second-degree murder, manslaughter while OUI, and leaving the scene of a crash resulting in death. She was convicted only of misdemeanor OUI count and received a year's probation. And then here's some supporters outside the courthouse with a big sign that says, Texas loves Karen, and they're doing the ASL sign for I love you. And it says, Karen Reed supporters cheer when she emerges from Norfolk Superior Court after the jury delivered its verdict in her murder retrial. Prosecutors allege that Reed backed her SUV in a drunken rage into Boston police officer John O'Keefe early on January 29, 2022, after dropping him off outside a Canton home following a night of bar hopping. Her lawyers said that she was framed and that O'Keefe entered the property owned at the time by a fellow Boston police officer where he was fatally beaten and possibly mauled by a German Shepherd before his body was planted on the front lawn. There's the one of the famous pictures of Karen and Alan Jackson. And you can see Liza a little bit, and David Yannetti with his arms up, and Bob Alessi over here in the corner. And you can see Janet Reed's face there also a little bit, holding up the ASL I love you sign as they're on the courthouse steps after the acquittal. Reed's first criminal trial ended with a hung jury last summer, and she still faces a wrongful death lawsuit brought by the O'Keefe family. Kearney, meanwhile, has pleaded not guilty to charges of harassing and intimidating witnesses in the Reed case, though some of the charges have been dropped. He suggested, well, they haven't been dropped, actually. They were actually dismissed by the court. They weren't dropped. They would never drop charges about Aidan Kearney. Boston Globe, get your act together. Do you need me to come and edit your articles? They didn't drop shit. Oh, sorry if I'm on the wall in a nail salon. He suggested via X that Affleck's in the pro-Reed camp, writing, he said, so she didn't do it, right? It's funny. He said, so she didn't do it, right? I wonder if Ben Affleck knew who Aidan was. I don't know. I have to say that I have beef with Ben Affleck and Matt Damon because neither one of them, who are from the area, ever got out and said anything about the trial, despite the fact that they have close personal ties to, as such, the Massachusetts area. And they could have used their platforms, and they didn't. So there's that. In another brilliant move, I needed to show you this because I thought this is brilliant marketing. You know the Coldplay thing with the people that were caught on the Coldplay cam. Well, Astronomer, the company that I forget what his position was, CEO, I don't remember what his position was, and the head of HR got caught canoodling at the Coldplay concert in Foxborough, right? Wasn't that where it was? In what I would call genius marketing move in order to turn this bad press for Astronomer into something more interesting. They hired Gwyneth Paltrow to do a spot for them. Oh, yes, they did. For those of you who know, Gwyneth Paltrow is the ex-wife of Coldplay frontman Chris Martin, and they talked about conscious uncoupling when they got divorced. And so here is what Astronomer did by hiring her to do this quick 1 minute long, 60-second spot for Astronomer. Listen to this.
Thank you for your interest in Astronomer. Hi, I'm Gwyneth Paltrow.
Genius.
I've been hired on a very temporary basis to speak on behalf of the 300 plus employees at Astronomer. Astronomer has gotten a lot of questions over the last few days, and they wanted me to answer the most common ones. Yes.
I'm going to have to keep stopping this, for fair use purposes. Here's the first, since many of you are driving and not listening or rage cleaning or whatever you're doing and you're not looking at the screen, I'm going to read the question to you. They wanted me to answer the most common questions.
And they wanted me to answer the most common ones. Yeah.
OMG, what the actual F? That's the first question.
Yes. Astronomer is the best place to run Apache Airflow, unifying the experience of running data, ML, and AI pipelines at scale. We've been thrilled so many people have a newfound interest in data workflow automation. As for the other questions we've received. Yeah.
How is your social media team holding up? This is genius marketing, by the way, because nobody knew what Astronomer was or what they did. And now we know it's a software company.
Yes, there is still room available at our Beyond Analytics event in September. We will now be returning to what we do best, delivering game-changing results for our customers. Thank you for your interest in Astronomer.
I mean, so many people were like, what does Astronomer do? What is Astronomer? That was genius. And it has been reported that they hired Ryan Reynolds advertising agency to produce that. And they've done a lot of crazy, very successful ad campaigns, including one for Match.com. I had a friend who was in that commercial with like the devil, with a guy that was dressed up like the devil. So that's pretty kind of genius, right? I mean, it's kind of genius. How much do you think they paid her for that 1 minute spot? Hell, a lot of money, I think. I thought it was well done. Thank you, Gigi. I will not read this out loud, but thank you for another super chat. Also, Marcy should not be walking in a parade. He should be on a float. Thank you. The first part of that I can't read because that could be, harassment. I don't know. Texas Katie said a judge in Massachusetts just dismissed over 100 cases because they can't afford to provide defense attorneys. Well, apparently the defense attorneys, the public defenders, or bar advocates, as they call them in Massachusetts, are only being paid something like $65 an hour. And they want to raise. And the legislature is like, yeah, well, maybe we'll give you another something, $20 over 3 years. I was trying to dig into that a little more deeply, and I don't want to give you the bad facts on it. But yeah, that's true. Who the hell wants plumbers make more than $65 an hour? Are you kidding me? It's insane. They don't value, apparently, public defenders in Massachusetts. So that's insane. Thank you very much. That is true. Attorney Wannabe, has Walshe declared a defense? Third party did it? Has he explained his shopping trips? No. He has the right not to speak or not to say anything, and he's chosen not to. So I have not seen a statement of the case yet. And we may see that before the trial. I don't know. Will it be the Shaggy defense? It wasn't me. Were they waiting to see what would happen with the evidence being excluded from the cell phones and stuff? So no, he has not. And he doesn't have to explain anything, really. They have to prove the case beyond a reasonable doubt. So we'll see. We will see. GG. I'm laughing because all I see, as you are saying what they are saying, I see that the court reporter with the what looks like a cup for a male athletic supporter, never a good look. I know they have that. That's the FTR system. They got to speak into that thing instead of typing on the stenography machines like we still do here in New York. Crazy, right? We pointed that out a lot in the Karen Reed trial. Thanks, Gigi. J Max says, I have so many questions. Thanks for covering this. I wonder if they broke Karen's other tail light, said Gigi. Well, apparently the car, they took the entire, computer system. They took everything out. They broke it. I don't even know if the car, it runs. I don't know if they need a tow truck to go pick it up. But I don't know if the car even runs after all of the destruction that they did trying to pull out all of the computer chips and systems and black box and all that other stuff. Tony, do you think Farwell's telling them everything? I have no idea what's going on with Farwell. I have no idea why they keep adjourning it. But the wheels of justice turn very, 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 very slowly. Thanks for your super chat. Lisa, motion for member Get Ready With Me stream. Love you, Mel. Yeah, maybe one day. Thanks, Lisa, for being here for 17 months. Bridget says, Farwell, October 6th for final status hearing and October 16th for a pretrial hearing. Yeah, they keep saying final, final, final. And then it's not final. Because there's not a lot of filings. I have to get back on Pacer and look at that when I will. We've been talking about so many things today. And off on so many tangents that that just came to mind because somebody sent it to me. Becky became a new member. Welcome. Kyle says, I got busy and came back to my mail. Still live. I'm here. It's only 3 hours and 10 minutes. Come on. We ain't got no quick. Kyle, what do you think this is? Some 2-bit amateur operation? Josh, so Massachusetts will pay a special prosecutor $250 an hour, but a public defender gets $65. Yeah. Yeah. And I think, I don't know what if anybody knows what the starting salaries are for like public, not for assistant DAs in Norfolk County. I think I saw somewhere once when I did research on this a long time ago, the starting salary may be like 90 grand a year. I think that Adam Lally, the year that he tried the Karen Reed case, and he's been there for 20 years at this point, was making 140 a year. Not a lot of money. And the public defenders in all of the neighboring states, I think in Maine, they get 150 an hour. Because I did say some information on that. That's a disgrace. It's criminal. And it's a big problem. Who wants that job at $65 an hour? Right? I don't know. KBD says the lowest paid state around Massachusetts pays their public defenders $112 an hour and up. So that's the lowest paid state around Massachusetts. Yeah. Horrible. So, I mean, these public defenders are barely making a living wage. It's insane. Somebody said they start at $35 an hour, depending on the charge. I don't know. I don't know. They got to pay their paralegals. Exactly. Oh, I'm sure she will sell the car because, they auctioned off like the OJ car and people will buy it. I think there was a recent article that said that the OJ car is worth could be worth up to like $1.5 million, that they were trying to auction it off again. She could auction it off. If it's hers to auction off, she may have just paid it off because she was still paying the lease and the lease probably expired. So I really don't know the status of the car. I have no inside information on that. But I would like to wrap this because I want to hear what Mike Crawford has to say about whether or not he's in trouble. And I'm sure you guys want to too. So let me see if he's live right now and then I can teleport you over there. Thank you to the moderators for keeping it classy today. It is never, ever easy when we cover the cases of Massachusetts. Never, ever, ever. He still has it as upcoming, so he didn't start yet. So I'm going to teleport you on over there. So apparently he's been threatened with criminal contempt charges for streaming or for trying to stream Lindsey Gaetani's hearing this morning. And let's teleport you over there and to support Mike Crawford and everyone else on the tubes of you who want to shout out to the public what the hell's going on in these courtrooms that they don't want you to see. And let me just see if I can do that. Everyone smash the like button while we're here talking about it because, it's the nice thing to do. It helps the algorithm. Share the stream out. Comment respectfully, please. And as always, stay cool, stay kind, stay classy. Let me see if he allows redirects. Some people don't. Some people do. He does. And so I'm going to send you over there and tell him, I said, Godspeed and good luck. And we know a lot of good First Amendment attorneys in Massachusetts. Stay cool, stay kind, stay classy. If I don't see you soon, I'm going to die. Make sure you're still subscribed and your notifications are set. And I will see you very, 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 very soon. And stop complaining. It's free, says Lady Lore. Stop complaining. It's free. Netflix, my Netflix is $36 a month now because I have so many users and so many children on my Netflix. So YouTube is free. So, complain to Netflix. You're paying $36 a month for that. Goodbye, everyone. Safe travels over to the Young Jurks.